Okay, I think that's everyone then. We can begin the meeting whenever you're ready, Justice Tucker.
Yes, please. Thank you.
Angela, if you could allow everyone to, all the panelists to show their video.
Oh, here we go. I did it, I think. There we go.
Good morning, everyone. Can you hear me?
Yes, we can hear you.
Excellent, super. Well, thank you, everyone. And I'm glad that everyone managed to find the link. I had trouble myself getting it all organized, but it looks like we have a very full house, which is absolutely wonderful. This is an exciting project that we are all about to embark on, and I'm so glad to see you all. Before we get started, I think, Ms. Lee, can you call the roll?
Yes, I'll do that. Okay. Justice Tucker.
I'm here.
Mary Baldwin.
Present.
Rebecca Sandifer. Are you with us, Rebecca?
Yes, I'm here.
Okay. Marta Alcumbra.
Here.
Reem Alos. Reem, are you with us?
Yes, this is Reem.
Okay. Judge Wendy Chang. David Engstrom.
I'm here.
Bridget Grammy.
Here.
Thomas Green.
Good morning, everyone. Yes, here.
David Grunfeld.
Daniel Gunfeld.
Oh, Daniel,
Yeah.
Sorry, I apologize.
No worries. Thank
Eric Helland.
Here.
Kathy Huang.
Here.
Micah Liberty.
Here. Good morning.
Good morning. John Lund.
I'm here.
Ruby Marquez. Ruby, are you with us?
I believe she said she was going to be late.
Okay. Kevin Moore.
Here.
Crispin Passmore.
Yeah, I'm here.
Toby Rothschild. Toby, you might be on mute.
There it is. Yeah, I'm here.
Okay. James Sandman.
Here.
Patricia Squitiera.
Here.
Okay, thank you.
Okay, thank you, Ms. Lee. This is a public meeting, and I'd like to start by finding if there are members of the public who would like to make a comment. If there are, I hope you have identified yourself through the raise hand feature. If not, identify yourself now, and I'll ask Ms. Lee whether we have members of the public who have raised a hand to speak.
It looks like we don't have any raised hands.
Okay, then let's move right into, by way of announcements, we're going to let everybody announce themselves. We want to spend the first hour of this meeting introducing ourselves to each other. We'll just go through every single member of the working group and the various staff and liaisons who we will be working with over the course of the next 2 years. And I thought I'd start by introducing myself. My name is Allison Tucker. My last name's not easy to pronounce, but it's like 2 kernels of corn. I am a justice on the First District Court of Appeal here in San Francisco. have been for a couple of years. Before that, I was an Alameda County Superior Court judge. And one of the reasons I'm passionate about this mission is because of some of the things I saw as an Alameda County Superior Court judge. I was in the family courts where we have large numbers of unrepresented litigants trying to make their way through the civil justice system with sometimes very little help and great needs. I also served for, I think it was about 5 years, on the board of the organization now known as Legal Access Alameda, formerly known as the Volunteer Legal Services Corporation of the Alameda County Bar Association. So that was my introduction to pro bono efforts to get civil lawyers helping in the courts with matters of the sort that later appeared in my family law courtroom. Before I became a judge, I was a deputy district attorney in San Jose for a few years, and a associate and then a partner at Morrison and Forrester doing complex civil litigation in San Francisco. So that's a little bit about my background, a little bit about my interest in this subject. And I'm going to ask each of you to share something about your background and your interest in the subject. And then just to keep it on the lighter note, those of you who are willing to share something of a silver lining from the gray cloud that was 2020 for all of us. And I'm just going to start by saying I'm the mother of 2 young adult children, and the silver lining for my 2020 was that they were both at home for extended periods, which I'm sure would not have happened without a pandemic requiring people to shelter in place. And that had a lot of really nice benefits for our family. So if I could pass the baton to one of my co-chairs to introduce yourself, please. Professor Sandifer, I see your name on the screen.
Sure. I'm Rebecca Sandifer. Most people call me Becky, and I hope that you all will do that as well if you're comfortable with that. I'm a professor of sociology at Arizona State University. And for most of my professional career, I've been studying access to justice from 2 sides. So how ordinary people think about and understand and respond to and are affected by their civil justice problems, and then both traditional and new kinds of services that might assist them with those problems. So how do they find those services? Do those services work? Are those services expensive, et cetera, that kind of thing. This is sort of the purpose of this committee, is the purpose of both my professional work and the motivation behind it, which is to make this a better place where people can use their own justice system and enjoy the protection of its laws. So it's a privilege to be working with you. And it's a kind of a nostalgic privilege because many years ago, I lived in California and I was on the Right to Counsel subcommittee of the Access to Justice Commission. So it's California is such an important state because it is a leader in many ways, and it's also huge. And if this committee can do something that opens up access to justice for some portion of the state's population, that's 50 million people whose lives are going to be better in a very fast way. So it's a privilege to be with you. I think my silver lining is I got very lucky and I moved to Arizona in the middle of a pandemic. And we could talk about the upsides and downsides of that, but the upside is the weather here is really nice all the time. And so you get to be outside and do things, not feel so closed in as I did in my previous pandemic months, which were in New York City. So if you want to live in a pandemic, desert, better than city. That's my advice.
Thank you. Mary Baldwin, please.
Hi, everybody. Mary Baldwin. I am a lawyer in San Francisco at Rogers Joseph O'Donnell. I also am a lecturer at UC Berkeley School of Law, where I teach professional responsibility. My practice focuses on issues of attorneys' ethics as well as attorney conduct. So both in the sort of ethical side as well as the liability kind of side. I represent both plaintiffs and defendants, so represent both clients and lawyers. And I come at these issues from all of those perspectives. I've had, as clients, lawyers and also non-lawyers who are looking to explore ways to provide legal services. I myself have a strong commitment to legal services, including pro bono. I was the president of the Bar Association and Justice and Diversity of San Francisco and Justice and Diversity Center a few years ago, and I was very involved in all of the work that the Justice and Diversity Center does, and I personally participate very actively in pro bono work. So I'm really looking forward to all of this and looking forward to working with all of you. Oh, I should also say, I mean, you can look at all of our backgrounds, but I used to, I was the head of the California State Bar's Committee on Professional Responsibility and Conduct. So I do have some limited experience of working in a committee like this and doing this kind of thing. And that's, I am looking forward to it. So thank you. Oh, silver lining. You know, like everybody, I think we've all had time to do sort of new things. And I have, I happen to live in Seattle now, although I still work in San Francisco. Complicated story, which we can share offline. The good thing about living in Seattle is I have just discovered, I'm middle-aged now, I like to go bird watching. In Seattle, I don't just go bird watching, I go eagle watching. So it's quite exciting. And I have wonderful photos of eagles if anyone's interested to see. So thanks.
Thank you. And Mimi Lee, can you just call through the roll again and we'll let people go one by one in introducing themselves?
Sure, no problem. Let me just make sure. Okay, so we'll start with Marta Alcambra.
Marta, if you're with us, you're on mute.
I am. I'm here. Good morning, everyone. My name is Marta Alcambra. Also not easy to say, but it all come back, but just put an R in there. So it's Alcambra. I'm a principal with Roby and Mathai in Los Angeles. I'm a certified specialist in legal malpractice law. I am soon to be the president-elect of the Association of Southern California Defense Counsel. And in my work with the ASCDC, I've worked with various different bar leaders and bar groups putting together a PI MSC mandatory settlement conference program that was very successful, and we're now moving it onto a virtual platform, which I think is kind of interesting on the technological side. I am really looking forward to being a part of this group. I think this is a really dynamic and interesting conversation to have. I share the views of Becky that this is a very interesting state. It serves a lot of people, and I think I'm really interested in working with all of you in looking at this topic. I feel I can speak for all of us that I really wish we weren't doing this via Zoom, but here we are. And I guess the silver lining for me is I have 3 children, and yes, we did spend a lot of time together, and I'm still really enjoying that. And also I'm wearing a lot more comfortable shoes every day. So right now, if you could see my feet, they're in slippers. But thank you, everyone, and I look forward to working with you.
I'm going to step in here just for a moment on behalf of Mimi and call Reem Alos.
Reem Alos, and I'm a manager at KPMG based out of the San Diego office. I work in the cyber practice. I have a background in computer science and software engineering. Prior to that, I used to have a patent firm, and I used to represent smaller clients with their patent filings with the United States Patent and Trademark Office. And so I have a little bit of kind of insights into those clients that have an idea and or a concept and want to have someone represent them for a reasonable fee. And then prior to that, I used to work at a startup. And so I have exposure to how outside capital can sometimes accelerate technology development. And then prior to that, when I was in law school, I worked at a tax clinic for about 6 months, and I represented clients that had very little money essentially to assist them with their tax, claims that were being filed from the IRS. And so we were assisting them on an as needed basis. So I have some experience there in terms of individuals that come to pro bono clinics for assistance. And so really looking forward to looking at ways where we can enhance the delivery of legal services through the use of technology and somewhat modifying the rules of professional conduct to allow for those services to take place in the marketplace. That would assist, legal professionals to be able to work and collaborate with technology and software development teams in order to be able to provide legal services to more people. Thank you so much. Looking forward to working with everyone.
Thank you.
Okay, Judge Chang, I don't believe is here. David Engstrom, please.
Hi all, good morning. I'm David Engstrom. I am a professor at Stanford Law School where I teach and write about civil procedure and administrative law. In terms of my professional background, I'm a lawyer and a litigator. I actually spent a good 5 years in practice in DC before I joined the Stanford faculty at a little litigation firm called Kellogg Hansen, where I did a mix of Supreme Court work and also trial work. I still do quite a bit of litigation work now. I also have a PhD in political science. I spent the last 3 years or so working on a set of research projects at the intersection of law and artificial intelligence, especially machine learning. And that would include the use of ML tools, both within the civil justice system, but also by government agencies. In addition to all that, I've spent the last several years in a role as an associate dean at Stanford Law, and my main portfolio has been thinking about law and tech, and that means both the school's substantive offerings, like how do we better prepare future lawyers for this digital future that's frankly already here, but then also pedagogical stuff, like for instance, what kinds of post-pandemic online instruction might make sense, like how can we reach new audiences. So that's me. The silver lining, I think for sure, has been time with kids. We have 2 boys who are 12 and 14. And so I think looking back, we'll think that this was a really great time and we'll kind of guiltily cherish it all the time that we've had in the house with them and getting to know them even better and understanding better where they're at in life. I guess I could add a further silver lining maybe too, which is that I think the first several months of the pandemic brought so many cancellations and obviously just killed dead all of the travel that I was doing at that point. And it's actually been a really nice opportunity for some professional reflection to actually take a breath and think about why I do what I do, what I want to do with whatever meager talents I can offer, including to efforts like this one. So I think that, that was a twofer. You got 2 silver linings out of me. So anyway, thanks. I'm so glad to be part of this group and I'm really looking forward to our work together.
Thank you.
Okay, next we have Bridget Grammy.
Thanks. I did notice that Judge Chang is here. Did you want to go first, Judge Chang, or should I go?
Why don't you finish yours and then we'll circle back to Judge Chang.
Okay. My name is Bridget Grammy. I am the director of the Center for Public Interest Law at the University of San Diego School of Law, and I teach public interest law and practice at USD. What we do at our center is we focus on California mostly state licensing agencies, occupational licensing agencies like the State Bar, and work on advocating for policies that are good for the public and make sure that the agencies are acting in the interest of the public and not in the profession they regulate. And so that has gotten me, over the last 6 years or so, I've been working a lot with the State Bar of California and advocating for different reforms. And I had the pleasure of serving on the previous task force to this, the ADJOURN task force, where I learned so much, and I'm really excited to be here with everyone to keep going on that work. My focus and on my subcommittee there had to do with this regulatory sandbox concept and how to deal with tech and ensure that access to justice is an important piece of this. And so consumer protection particularly is an important aspect of my work, and it's something that I look forward to bringing to all of you. So that's a little bit about my background. Before I've been working at USD, I was a civil litigator for 10 years. Most of my time I spent in antitrust law and in plaintiff's work. So that's the background that I bring to this as well. So silver linings, you can see her here. Her name is Ellie. So there she is. She's sleeping. Hopefully she was born in June. And she was a real surprise to us. We have two daughters that are 11 and 13. And then Ellie is an extra little bonus during 2020. So I share a lot of your reflections about being able to spend more time at home, not traveling, and getting the chance to pause and think about what I really care about. And this is work that I just truly enjoy and I'm very passionate about. So thank you very much for including me.
Thank you.
Okay. Next, Judge Wendy Chang.
Hi, everyone. I am Judge Wendy Chang. I am with the Los Angeles Superior Court. I have an independent calendar, a limited jurisdiction civil calendar, and I sit in Lancaster, California, which is the very, very, very north part of LA County. If you're ever driving up Mammoth, you can wave at me from the freeway. So before I joined the bench, I represented lawyers for a living, both in litigation and in regulation and in ethics and professional responsibility counseling. I have served on the ethics committee with the state bar and with the ABA. And I was also on the adults task force. I think as a combination of all of that, I think the real need for this type of the work that we're going to be doing now, why the industry needs it so much. I see self-represented people come into my courtroom all the time, and the impact, the lack of ability to access lawyers and the impact it has on their cases, and how frustrating it is for them, and sometimes even for their, if there's counsel on the other side, to deal with them. And so I am really excited for this effort, and I am really glad to be here. I look forward to working with all of you. I see so many familiar faces. It's really nice. Kind of feels like a little bit of a reunion, and so very happy to see you all. Looking forward to it.
Thank you.
Okay, next, Thomas Green.
Hi, all. Tom Green. I'm a trial attorney with the Antitrust Division of the U.S. Department of Justice. So my current major assignment is United States versus Google. And I had the opportunity to actually argue the first motion in that case about 2 weeks ago. I'm a member of the board of the California Lawyers Association. I'm the former chair of the litigation section. My time with the litigation section, I'm still active, but when I was chair, we were able to develop new programming for improving the core skills of younger lawyers. So we're trying to make them more effective earlier in their careers. And I was also very excited to be involved in creating our Veterans Committee. So this is an underserved population with a very unique set of legal problems, many of them kind of in the administrative law space. So we developed a training program and some other things associated with trying to improve services to that particular group. I too teach. I'm the co-teacher of UC Hastings core antitrust course. And I must say, I wish I'd started teaching way earlier in my career than I did, because it's one of the best things I get to do during the year. And then finally, in terms of a silver lining for us, probably the best is our youngest son and his wife are pregnant. They're expecting their first baby later in January. So this will be their daughter and our granddaughter. So we're very excited that 2020 and now 2021 are bringing this delightful gift. So that's me.
Thank you.
All right, next we have Daniel Grunfeld.
Hi, everybody. I'm Dan. For 10 years, I was the president and CEO of Public Counsel, which became the largest public interest pro bono law firm in the United States. After that, I became one of the 4 members of the executive team assisting then Mayor Antonio Villarosa, and I was in charge of policy coordination for the administration. I then went back to where I started. I was a co-managing partner of Kay Scholer's West Coast offices in LA and in Silicon Valley, and then became the leader of Morgan Lewis's litigation practice. I'm still heavily involved with pro bono and public counsel. I'm scheduled to assume the chair of the board of public counsel in 2 years. In terms of silver linings, if I may, two. In very late January, right before the world closed down, our son David got married to a wonderful person, Sophia, who is, of course, a lawyer. And for many of us and for our guests, this was the last happy mass celebration that we got to enjoy. But even that pales in comparison to the fact that the other silver lining is that after 30 years of living with my wife, Colleen, in the same place, the closets have never been so decluttered and organized.
Excellent. Thank you.
Okay, next we have Eric Helland.
Hi, I'm Eric Helland. I'm actually a professor of economics at Claremont McKenna College, which is in Los Angeles, kind of up against the mountains. I'm also a senior economist at the Rand Corporation, where I'm part of the Institute of Civil Justice. So my primary research area is empirical legal studies. And I sort of came to this, a lot of my research is in civil litigation over the years. I actually came to this sort of in the reverse through studying judges, and a lot of judges that I've been talking to, particularly on the RAND board, have been talking about the impact of essentially pro se litigants on the functioning of the courts. And so I sort of came at sort of studying sort of representation issues actually from the impact of the courts, and then I'm now doing a project with the ICJ, basically looking at unrepresented litigants in bankruptcy proceedings. So I'm kind of coming at this from a slightly different perspective. My silver lining, I think, to continue the theme of getting to see a lot of adult children, but I will say the one that is relevant kind of for this one is my youngest daughter was actually forced to come back from an internship and live with us, and the internship was working with Jim Greiner at Harvard's Access to Justice Lab. So we've been having a lot of conversations about this meeting from our sort of different perspectives, because she's been working on randomized control trials on the role of representation in various cases. So, so my silver lining is having another person to talk about this with at home who actually also knows something about the subject.
Thank you.
Okay, next we have Kathy Huang.
Hi everyone, I am Kathy. To start off with, I come from a community health background, so helping to achieve equity and eliminate disparities is always sort of a North Star for me, which is a reason why I decided to join this group. And I'm currently the Senior Director of Data Evaluation and Development at the YMCA Metropolitan Los Angeles. So we have 26 locations throughout the county. And one of the activities that I'm involved with here is I'm one of our Department of Justice accredited representatives through the Executive Office of Immigration Review. And I've also been involved through the YMCA with our Equity and Inclusion Initiative. We have several activities and resource groups here, which I haven't seen at other places that I've worked, so it's pretty exciting to be involved in this type of work. Previously, I was the president at the Southern California Society for Public Health Education, and I've been involved with that organization for several years prior to that in different roles. And then for silver lining, mine will be a little bit different. Mine is that I was able to tap into my artistic capabilities, which I hadn't been engaged in since I was a child. So I've been really enjoying this quiet time to paint and just do arts and crafts. And it's been really different from the pre-pandemic life, where it was kind of always go, 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 and it's a nice time to pause. But I am happy and excited to be here. I'm blown away by everyone's backgrounds and expertise. So I'm excited that I'll be able to provide a different community perspective to everyone. Thank you.
Thank you.
Okay, next we have Micah Star Liberty.
Morning, everyone. My name is Micah Star Liberty. I'm a plaintiff's lawyer and a trial lawyer, or at least I will be when we can get back into the courtroom and try our cases. At Liberty Law, which I've had for 15 years, we are a employment and catastrophic injury firm. However, my practice really focuses on representing survivors of sexual abuse, assault, and harassment. We also represent special needs individuals in physical abuse cases. I've been involved in and led several legal organizations. I was a board member of the state bar, and most recently I just finished my one-year presidency of the Consumer Attorneys of California. It's the state's largest plaintiffs lawyer organization. Before I went to law school, I worked in politics on presidential, US Senate and congressional races, and then worked at the White House and on the Hill. I'm really excited to be here. I think this is going to be an interesting process. I had a number of COVID silver linings. Actually, there was a lot of time to really focus on, ways to do things differently. So at my firm, we've really put a lot of effort into our client relationships and client satisfaction, which has been fun for me. I used to spend a lot of time traveling around the country, working on cases outside of California and speaking on a variety of MCLE topics. And since I wasn't having to live on airplanes and travel, I actually was able to do a lot more because I could do a couple of different MCLE lectures in a day by Zoom. On the personal front, when everything shut down, my mother was visiting. So I was lucky enough to have my mom with me for the first couple of months of the shutdown. First time we lived under the same roof since I was 18. So that was fun. But there are a lot of different COVID silver linings. And hopefully we will get through this process with silver linings ourselves. It's a pleasure to be here.
Thank you.
Okay, next we have John Lund.
Hi, everyone. Really great to be here. I'm enjoying these introductions. I am a practicing lawyer over 37 years, primarily litigating cases throughout the Intermountain West. I'm currently with a firm in Utah that you probably don't recognize because it's Utah, but it's a 150 lawyer firm called Parsons, Bailey, and Latimer. And I try cases for ski resort developers and all kinds of different people who have business disputes. I also have an economics degree, which plays into this, I suppose, in terms of my interest, because and I'm very interested to hear we have some economists on the group because of the economic drivers that maybe can help us with our problem of access to justice. I currently chair at the Utah Supreme Court's pleasure their innovation office here in Utah, which runs the sandbox that we established here in Utah. And I've been involved in that effort for the last couple of years here in the state, co-chairing a task force with Justice Dino Himonas, and then another one that implemented it, in which we were fortunate to have Becky Sandifer and some other luminaries from across the country join us. So we've been very appreciative of all the support and interest in what's going on in Utah so far. When we started this, Himonas and I, just to quell any concerns about this, we were having whiskey together, even though we're from Utah. And we felt as though if we could just even have any influence on the 5th largest economy in the world, that being California, that we would have made some, benefit to everybody. So hopefully that's what will come out of this group's efforts. I've mentioned this to a few people that I see on the phone, like Jim Salmon, but you should go look at that crazy man dancing video of the guy that starts to stand up and dance first. And then hopefully other people join to the point where that crazy man doesn't look quite so crazy. And that's, I guess, how I sort of see Utah in this process. And we're glad to see some other people at least thinking about getting up and joining the dance. And because it's just so exciting to have people who are so committed to improving the way legal services are provided to people across the entire economic spectrum involved in this effort. So that's great. The silver lining, in addition to many of the things other people have mentioned, I'll just say, I finally understood what dogs do all day long. And I think that, you know, there's something to learn from them. Thanks.
Thank you.
Okay, I think Ruby still hasn't joined us, so we'll move on with Professor Kevin Moore.
Hi, Kevin Moore. I'm a professor at Western State College of Law in Irvine, California. I teach contracts, remedies, legal ethics. I directed the judicial externship program at our school for several years. And I also, prior to teaching law school, which I've been doing for about the last 30 years, I had an intellectual property practice. And I taught intellectual property, but I haven't done that in well over 10 years. My place on this excellent body appears to be because of my familiarity with legal ethics. I've been involved with the state bar and local bar associations, their ethics committees, and I was fortunate to be the consultant to the Rules Revision Commission and assisting in the drafting of the new rules of professional conduct, which is how I think I got brought in to contribute to the ADLs, or depending on your point of view, the ADLs task force that preceded this working group. I'm looking forward to being here. I'm going to be, I can help out with drafting. So if you have any drafting issues and have any questions, I'll be happy to help with that. My silver lining this last year, I'm going to kind of piggyback on what John just said about dogs. Being around my dog, I was able to notice quickly that he was in perilous condition. He had an emergency gallbladder surgery this summer. He survived, only to discover that he had cancer in one of his anal glands. He survived that operation as well. And he's still with us. He's quite alert and quite large, and he barks a lot. You may hear him sometime during the meeting. Thank you.
Thank you.
Okay, next we have Crispin Passmore.
Thanks very much. I'll take the liberty of saying good evening from England. After a full day work, it's a pleasure to come and spend 6 hours remotely in California. My background, I'm not a lawyer, I've never been a lawyer, but I've worked in the legal industry for 3 decades plus. Can't quite think just how many years. I started out doing pro bono work in a charity whilst I was doing my undergraduate degree. And ended up running the largest pro bono charity for legal services in England. I was exec director in legal aid, which is a $3 billion budget back then in England. And I helped set up the Legal Services Board following the Legal Services Act in England and Wales, which is the significant liberalisation that I'll talk a bit about later. And most recently in executive career, I was exec director at the Solicitors Regulation Authority, which regulates about 200,000 lawyers and 10,000 law firms, and led most of the reforms that have happened here in recent years. The last 2 years, I've worked for myself, run a consultancy business. Most of my paid work is with legal businesses that are trying to do things differently, whether they're alternative providers, law firms, startups, big and small, professional services firms. Lots of that is in the US as well as the UK. But I also do quite a lot of work, predominantly pro bono, with regulators around the world to help them think about the issues that you're all interested in California in. I guess I set up a sandbox at the SRA nearly 7 years ago as part of our reforms. So hopefully I can bring some experience to that. I'll be doing a presentation later about England and Wales regulatory system. My silver lining, I should say, shouldn't I? I've got to spend more time with my children, but I think they'd agree it's much more important that I got more time to spend with my wine cellar. I've been able to organize it, and I've been able to, in lockdown, spend a lot more time at home drinking it rather than going out and drinking poorer quality stuff. So that's much more important than spending time with my children. And they think that too, to be honest. I quite happily show a video of that instead of doing my presentation later if there was a decision in favor of that. Thank you very much.
Thank you.
Okay, and next we have Toby Rothschild.
Hi, I'm Toby, and I've spent the last 50 plus years as a legal aid lawyer. Started in Long Beach, California, and was the executive director of the legal aid program in Long Beach for about 28 years, and then merged into the Legal Aid Foundation of Los Angeles, where I was general counsel and did a lot of work on ethics and training and consulting on professional responsibility issues. I formally retired about 6 years ago, and since then have been doing, on a pro bono basis, ethics consulting and training for all of the legal aid programs in California. Interesting, and knowing it's January, which means it's the last month before the MCLE deadline, I have 7 presentations this month to fit in. I've done a lot of work with the State Bar, and in the recent years, I was on the State Bar's ethics committee. I was on the Second Rules Revision Commission. I served as a co-vice chair of the ADLS task force, and I'm glad to bring all of that here, both the legal services background, the ethics background, the ADLS history. In terms of a silver lining, I mean, unlike a lot of you who got to spend time with your children, mine are grown and out, which meant I got to spend less time with them, and more importantly, less time with the grandkids because they're remote. I mean, they're nearby, but can't exactly go visit every day. But I did get to spend more time with my wife of 53 years and spend more time working with her and being around the house. But I guess the greatest silver lining of 2020 for me is that it ended.
Okay, next we have James Sandman.
Hi, I'm Jim Sandman. I'm in Washington, D.C. Since last May, I've been a member of the faculty at the University of Pennsylvania Law School, where I also work with the school's Future of the Profession initiative on several access to justice projects, including regulatory reform and simplification of legal process. I'm President Emeritus of the Legal Services Corporation, which is the country's largest funder of civil legal aid programs. I was president of LSC from 2011 until February of last year. I've spent most of my career as a litigator in a big law firm, Arnold & Porter, for 30 years. I worked in the firm's Washington, Denver, and Los Angeles offices. I helped to start the firm's Los Angeles office in the early 1990s, and our daughter was born in LA, so at St. John's Hospital in Santa Monica. So I have a very fond connection to California. I served as managing partner of Arnold & Porter for 10 years. I am involved in local access to justice matters in the District of Columbia. I'm a past president of the District of Columbia Bar. I'm vice chair of the DC Access to Justice Commission, and I serve on the DC Bar's Pro Bono Committee. I also do pro bono work at clinics that serve low-income people in my city. The silver lining for me is like that many others have mentioned. Our daughter works for the Federal Public Defender's Office in Maryland. And she's moved in with my wife and me for the duration of the pandemic. We're all in law. So we've got 3 of us living and working in a 4-room condo, which makes for a lot of togetherness and heavy strain on our Wi-Fi. It helps that we like each other a lot. But it's really wonderful to live with an adult child and to see the life that your kid has created for herself, a real blessing. I'm really grateful to be a part of this group. I admire what you're doing in California and hope I can help.
Thank you. Is Patricia Scutiero on the line?
It shows her that she's on.
Hi. I think I'll try to make it short, but I tend to talk a lot. So basically, I'm an immigrant. I went through the USCIS process, and I'm also a naturalized citizen at this point. I'm a consumer of various, I'm coming in as a consumer from the legal side. I'm just basically here because when I arrived in California a few years ago, I was recovering from a mild traumatic brain injury, and that impacted my visual perception and hearing. And I had to navigate through the challenges of working through a software company. It actually helped me to design software that, for people who are under ADA accommodations. I have a background in biology and forensic science and some product management. I've also co-authored in a peer-reviewed scientific journal. I support research compliance, such as compliance within clinical trials, like, getting FDA approval for this COVID is an example. So I'm interested in looking at the intersectionalities of access within the marginalized communities of, especially non-native speakers, and perhaps, we can work towards a multilingual platform with this access of, for the legal software. I've also volunteered for skills enhancement programs of people within marginalized communities in the past to help them to build confidence, to feel like they can go to college. I did that as a weekend program. And I say a lot, but basically my silver lining, I have a couple. My daughter has graduated from college, so we didn't have that concern of her being on the college premises during COVID. We're in touch via Zoom. She's on the East Coast because she likes the cold. But also, because she's the first generation Latina, I wanted her to see that women in the Latinx community can have a voice, and that we can challenge things and ask questions and gain access in a peaceful way. So offering me an opportunity to be on this is a privilege, and I'm honored, and I thank you all.
Thank you.
Okay, next we have Neil Gupta.
Yeah, hi folks, I'm Neil. I work at the California Supreme Court, where I am Principal Attorney Chief Justice. I've actually been a judicial attorney my entire legal career, started at the Santa Clara Superior Court, and then now here at the California Supreme Court. I have to say this is a very impressive group, and I'm really looking forward to see what comes out of here in the next 2 years. But in terms of silver linings, I would say not having to drive in traffic. It makes me and my clutch very happy.
Thank you.
Okay, next we have Greg Fortescue.
Hello, everyone. I'm Greg Fortescue. I also work with the California Supreme Court. I'm a lead attorney with the court. I've been with the court for 7 years. Prior to that, I was a civil litigator for 7 years. I came to law late in my career. I started out in my 20s as a professional actor. I have my MFA in theater from American Conservatory Theater. And once I hung up the pumpkin pants, I started teaching elementary school in New York City, where I met my wife. Why did I become a lawyer? My father was a solo practitioner in Detroit growing up, and I always admired him. He never intended to do pro bono work, but he was a guy with a big heart, and he took a lot of hard luck cases. So by default, he ended up doing a lot of pro bono work. And the problems that he dealt with, from our vantage point at the court now, I have a different vantage point now, and I realize how it's gotten a lot worse since he was practicing. And I'm really looking forward to the work of this group, and honored to work again with a number of people that I collaborated with on the Second Rules Revision Commission. And I also was with ADLs for a period of time before I went temporarily insane and returned to civil litigation for 9 months, and then came back to the best job I've ever had. So looking forward to working with everyone.
Thank you.
Okay, next we have Donna Hershkowitz.
Thank you. Good morning, everybody. Good evening, Crispin. I'm thrilled to have all of you here with us today for the inaugural meeting of the Closing the Justice Gap Working Group. I am the interim executive director here at the State Bar. And in my off time, I'm the chief of programs at the State Bar. I say that only to point out that that the work of this group would be under my my purview, regardless of which role I'm in. And I spent a fair amount of time with the ADLs group last year, and look forward to the work that this group will be producing this year. I think it is innovative and exciting, and we have an opportunity to really improve the access to justice for people who don't have access currently, to provide some real opportunities, and to take a fresh look at what it means to practice law and the way we practice law in California. My silver lining, I would say, is twofold. On the personal front, and this is going to sound bad, but I don't mean it that way. My stepdaughter actually, unlike most of her cohort, actually had the opportunity to go away to college last semester. Her university had some of her classes were in person, and so on her behalf, that was a silver lining. On a professional note, I think the State Bar, like so many other entities, have really learned a heck of a lot about the ability to work from home. And I look forward to making intentional decisions in the future when the choice is ours, that would really take advantage of what we've learned and be able to improve the work experience for a lot of folks by allowing them to work from home more frequently when that is our choice. Thank you.
Okay, I'm going to cut in line real quick because myself and Angela Marlowe need to attend a coworkers memorial service on Zoom. So I'll just go ahead and go first, and then I'll let Angela introduce herself. I'm Mimi Lee. I'm in the Office of Professional Competence. I'm a senior program analyst. I've been at the State Bar for, I would say, about 14 years. And I currently staff the COPREC, the Ethics Committee at the State Bar. And I've staffed the Rules Revision Commission and ADLs. And I've had a lot of experience with all these committee type activities. I'm also responsible for a lot of our publications and website ethics related web content. My silver lining, there's probably two. One, I got a Peloton, which my sister kind of encouraged me to do, and she's in Texas, and you know, if we were working in the office, we can never work out together because by the time I get home, it's already 8 p.m. for her, and she's got to put her kids down. So my silver lining would be that we get to work out together in the mornings. You know, for me, it's at 7 o'clock. For her, it's at 9 a.m. So we get to do it via video. And then the second thing would be that I do an annual trip to Hawaii. And since all my international travel was canceled this year, still got to go to Hawaii. And it was the best trip I've ever had. Not crowded at all. All the restaurants allowed reservations. So I got to eat a lot of good food and enjoy the beach without it being crowded. So I'll let Angela go next.
Thanks, Mimi. Good morning, everyone. My name is Angela Marlowe. I am the program coordinator for the Office of Professional Competence, and I will be your primary contact person for this committee with administrative matters, anything having to do with assignments, really anything. Feel free to email me and I will help you get the help you need. My silver lining during this year has definitely been spending more time with my two boys, 7 and 3. It's been really nice not having to commute and to have that extra time to do the small things with them. And I really look forward to working with everybody. Thank you.
Thank you.
Okay, I'm going to step in and hand the baton to Randy.
Good morning, everybody. Randall Diefentorum. Another hard last name, Diefentorum, but please feel free to call me Randy. It's been my privilege to work with many of you, some recently, some from several or many years ago, and it's nice to work with you again. I really appreciate that. It's one of the greatest pleasures of actually working at the State Bar that I've been able to work with so many excellent volunteer groups. And I must say, this might be the pinnacle of all the volunteer groups I've served, just hearing the introductions around the table today. I've been with the State Bar for many years. When I was in law school, my aunt who worked at the State Bar said, there's this program called the Ethics Hotline, and the receptionist is taking a long summer vacation. Do you want to temp at the State Bar? And I said, ooh, work at the State Bar? She says, but you're thinking of going to law school. Don't you want to learn about lawyers? So I took her up and I temped at the State Bar and was the receptionist for the Ethics Hotline program. And after law school, I actually came back and I haven't looked back since then. One thing I have learned in being affiliated with the Ethics Hotline program for many, many years is that there are so many attorneys in California who really want to do the right thing. They call the Ethics Hotline not looking for an end run around rules, but are trying to advocate as much as possible, do the best possible practice for their clients, access included, but are rule followers by nature. And if this group can effectuate changes to the rules so that these attorneys who want to do the right thing can actually expand their delivery of legal services, I think that would be a momentous accomplishment. My silver lining to the chagrin of my spouse is that I stopped shaving, but I think a lot of folks did. Thanks.
Thank you.
Andrew Tuft.
Good morning, everybody, and good afternoon and good evening for some of you. My name's Andrew Tuft. I'm the supervising attorney in the State Bar's Office of Professional Competence. I report to Randy and I work closely with Lauren, Angela, and Mimi. One of my primary tasks is to supervise the State Bar's Ethics Hotline. I also serve as staff counsel to the State Bar Standing Committee on Professional Responsibility and Conduct, oftentimes referred to as COPRAC, who's tasked with writing State Bar ethics opinions, as well as revising rules of professional conduct. In that role, I've had the pleasure of working with a handful of you who are on this group, and it's great to see you again. I've also staffed the Rules Revision Commission and the ADLS Task Force. And in those roles, I've also worked with several of you who are here today, and it is truly an honor to see you again, and also being able to observe all the introductions this morning, as Randy said. It's really impressive group, and I'm hopeful my meager services could be of assistance to you all throughout this process. In terms of silver linings, I made an impulse purchase shortly after March and early April. I figured I'm going to be home for a long time, and I'm going to be around the house for a long time. And what can I do? Well, I'm home and around the house for a long time, but nowhere to go. And I thought I could smoke some meat. So I purchased a meat smoker. And since that time, I've experimented with things such as pulled pork, ribs, brisket, prime rib, chicken, and it's been really enjoyable. I've sought various recipes. Sometimes it's an all-day event, and it's been a lot of fun, and I've gotten my kids involved in it, and it's been really rewarding. So thank you.
Thank you.
Okay, I'm going to go next to complete the Office of Professional Competence support team. And then we have some other State Bar staff. But hello, everyone. I'm Lauren McCurdy, and it's nice to meet you more or less in person after the many email communications that I've exchanged with you all. I am here in a lead administrative support role, along with the assistance of Mimi Lee and Angela Marlowe. Probably going to be transitioning more of the communication, the lead communication role to Angela. So you'll be hearing more from her, but we'll be working together. I have worked at the State Bar since 1983, and in many roles, primarily in the area of the professional responsibility and legal ethics resources that the bar offers, and have supported many volunteer bodies, the same ones that have been mentioned by Randy and Andrew and others. And it is, the supporting of the volunteer bodies is really one of the more rewarding aspects of the work of our office, to see the passion and dedication of so many volunteers and the civility and professionalism. To not repeat many of the other silver linings that have been out there, which I could certainly sign on to as well. I'll go with the easy one that is in line with the commuting one that I think Neil mentioned, and that is that I'm happy to have a break from a nearly 30-year commute on BART. It's been very nice to not have to get onto the train and get into the mix of that commute from the East Bay into San Francisco. So me. Next up is Melanie Lawrence.
Hi, good morning. My name is Melanie Lawrence. I am interim chief trial counsel in the Office of Chief Trial Counsel at the State Bar of California. I have been with the office for 15 years. We are the office that investigates and prosecutes misconduct complaints against licensed attorneys in California. My legal career has spanned a number of different aspects of the legal system, including that I have worked in legal services in the state of Washington. I have been an adult parole and probation officer in the state of Oregon, and I have been a deputy district attorney in Queens, New York. My silver lining is that I too am a dog lover. So not only have I been able to spend time with my two old guys, but I have done some dog fostering, which has been both rewarding and a great distraction. And I am happy to serve as a staff liaison to this group and happy to be of service.
Thank you.
Mia Ellis.
Yes, thank you. Good morning, everyone. I'm Mia Ellis. I'm a manager in the Office of Chief Trial Counsel. I report to Melanie Lawrence, and I've been on the Adults Task Force as well. Our office enforces some of the rules that we will be discussing for possible amendments. So I'm looking forward to that discussion. I've been with the bar for about, I think 12 years actually this month. So it's been a long career here in different positions within the bar. Prior to my bar service, I worked in private practice for a few years. My silver lining, I think, is twofold. One, certainly a lot of time for personal reflection, which is always good. And I actually was also happy to hear Andrew's, because mine is also food related, in that I was reacquainted with my kitchen and I baked a lot. So last year I bought a lot of flour and sugar, more than I've ever in my life.
Thank you.
And last and definitely not least, Brady Dewar.
Hi, everyone. Good morning. My name is Brady Dewar. I'm an assistant general counsel in the Office of General Counsel, which is sort of the State Bar's in-house law firm. I've been at the State Bar for 3 years. My background before that was about 10 years in civil litigation, first at a large firm, Morgan Lewis, and then at a boutique, Curran Wagstaff. I worked with, in a similar capacity, with the Adults Commission, and really enjoyed that work. So I'm looking forward to this. My role is sort of, to help with basic compliance issues, bag leaking. I know we're going to get a presentation on that, public records requests as they come in, and also to help as necessary with answering legal questions related to process, what the bar's authority is in various areas, how the moving pieces work with the Supreme Court and the legislature, and questions of that nature. So I'm really looking forward to this work. Silver lining, I have a 7-year-old and a 5-year-old at home. I almost called her a 3-year-old. It seems like yesterday. And while that's obviously led to some of the biggest challenges of the year, one silver lining is we've needed to find things to do. And we've really upped our game on beaches, shorelines, hikes throughout the Bay Area. And it's been really a nice thing.
Lauren, do we think
Hey, that wraps up all of the presentations.
I know our organization, I know our work group was, I believe someone has been designated from the California State Assembly as a liaison. Is that person here today?
Let's see. That is, I believe that's Ruby Marquez.
I see, okay.
And she is running late and maybe here in the afternoon, the early afternoon.
Well, we'll come back to introductions then if there are some to pick up later, but mostly I think let's roll into the brief part of the morning's program that starts with, I believe, a State Bar presentation. We got a series of very short State Bar presentations.
I'm waiting, hold on one moment. I just need to make sure that our staff presenter has joined. Just a second here.
And if Suzanne Grant isn't on the line, perhaps we could just reorder the order of them.
Sure, just give me a moment here.
Suzanne is connecting right now.
Fantastic, thank you, Donna.
Suzanne, you are up.
Well, Suzanne is getting her video.
Oh, I'm here. Sorry.
Oh,
I actually am not gonna be able to use the video because I want to share my screen through the remote desktop, and my remote desktop doesn't have a video. So is that okay? You're just gonna have to listen to me. I'm just getting the screen up. Apologies.
Suzanne's going to be talking to us about the very important subject of the Bagley-Keene Open Meeting Act and the California Public Records Act and what we need to do to make sure we are in compliance with both of those.
Hi, okay, can you hear me okay? I'm gonna share my screen now. Once again, apologies for not having video, but it's a pleasure to see all of you. I'm just gonna get the PowerPoint up, okay. Does everyone see that?
Yes.
Okay, so good morning, everyone. Yeah, my name is Suzanne Grant. I'm an attorney in the Office of General Counsel. Let me just make the slide make it bigger. I handle issues relating to the Bagley-Keene Open Meeting Act and the California Public Records Act. And this training just provides an overview of those two laws and talks about what you might need to know as a member of a state bar committee and highlights certain things you should keep in mind considering the state bar is subject to both Bagley-Keene and what we call CPRA, short for California Public Records Act. So we became subject to the Bagley-Keene Open Meetings Act. I'm going to start with Bagley-Keene, and then we're going to do CPRA afterwards. The State Bar became subject to the Bagley-Keene Open Meetings Act April 1st, 2016. Before that, the Open Meetings Act applies to different state bodies. It's been in effect for a number of years, but we had not been subject to it till April 1st. The Bagley-Keene Act applies to the state bar. Under the Business and Professions Code, they call it just the state bar. They don't specify what that means. We'll talk about what that means. It does not apply to the Judicial Nominee Evaluation Commission or to the State Bar Court. So those two entities of the state bar are exempt from Bagley-Keene. The Bagley-Keene Open Meeting Act is based on the concept of transparency in government. So these were just some quotes that talked about, the basic concept of why this law is very important. We want to encourage people to participate in meetings of the government entities. The state bar is a government entity, and our committees and commissions are part of the state bar. So we want to encourage public viewing of meetings, public participation. Now that we do have, a pandemic, we do our meetings over Zoom as we're doing now. And doing those meetings over Zoom means the public also has a right to see them and participate in the Zoom meeting. Like I said, the Bagley-Keene Open Meeting Act applies to the state bar. So what that means is we look to the act itself, which is in the California Government Code, to find out what it means to be covered by Bagley-Keene. And by covered, I mean you have to comply with the different requirements of the act in terms of how you have meetings, when you post notice of the meetings, etc. So the act applies to state boards, commissions, committees, or multi-member bodies created by statute. And that's really, the state bar. That's our board, and that's subject to Bagley-Keene under that. And then the second one is boards, commissions, committees, or multi-member bodies that exercises authority delegated by a state body. So that would be, if the board creates commissions, committees, and these commissions and committees have decision-making on behalf of the state bar, they're subject to Bagley-Keene as well. Then there are advisory boards, advisory commissions, or committees, or similar multi-member bodies of 3 or more people that are created by formal action of a state body. So that means that the board or any committee that the board delegates authority that are subject to Bagley-Keene can create their own committees and commissions. Usually by formal action, that usually means by a formal resolution. However, it doesn't have to be by resolution. It can be a chair of the board or chair of a committee can create a group, and that group would then also be subject to Bagley-Keene. However, the group has to consist of 3 or more persons. So that means the board could say, I want to create a group of 2 people to talk about an issue or work on an issue. And because that there's only 2 people, that group would not be subject to Bagley-Keene, provided, however, it doesn't exercise authority on behalf of the bar. Because if it does exercise authority, it's still subject to Bagley-Keene. So you can't get around it by saying we're only going to have 2 people that's going to do this action on behalf of the board. So the keyword is advisory. So if they're just an advisory group and there's 2 people, they're not subject to Bagley-Keene. The last one is official representation of state bodies serving on another board or commission supported in whole or in part by funds provided by the state body. So that would be, such as a board member serving on another type of state body, another type of committee or commission, and the state bar was providing funding, that might be subject to Bagley-Keene. So we often get questions about task force and working group. So I wanted to just highlight that in terms of deciding whether that task force or working group would be subject to Bagley-Keene. So as I stated before, you want to look at, how many people are in the group. If it's less than 2 people, it's probably not subject to Bagley-Keene because it has to be 3 or more people and formally created. And like I said, if it's 2 people, they have to be actually exercising authority on behalf of the bar. Is it an advisory body, which means that, is it taking any action? That's, what I just said. If they're not taking any action, their advisory usually means making recommendations to the board or to another commission. Does it have authority? Was it created by staff? So that's really a key decision point we use, that if it's created by staff, that's not considered formally created. So if staff wants to create a working group, they can create a working group of more than 2 people. They can create a working group of 4 people, of 5 people, as long as it's not a majority of another state body. That would make it a meeting of, that would make it a state body. We'll talk about that in a second. But staff can create its own groups, and that's not subject to Bagley-Keene. So that's often sometimes what we do if we want to have these informal working groups or task force that we, that are not, we don't have to worry about complying with the open meetings requirements. Was there a resolution regarding its creation? So that usually means it's formally created by the board, and also who is serving on it. So as I said before, if you have a majority of members of a state body, that makes it a meeting of that state body. So when I say staff can create a working group, if staff creates a group that consists of more than a majority of members of, let's say, the board, even though staff created it, it's considered a meeting of the board. So we're going to talk about what a meeting is. So Bagley-Keene Open Meetings Act applies to meetings. They talk about, when meetings have to be public, when meetings have to be noticed, etc. So this is a statutory definition of a meeting. It's a congregation of a majority of members of a body at the same time and place to hear, discuss, or deliberate upon any item within the jurisdiction of the body. So that's why I highlighted majority before, because if you have a majority of people that are members of a body that's subject to Bagley-Keene, that means that anytime they're in a group together at a meeting, at a time and place, it doesn't have to be in person. It can be over email. It can be on a telephone call. That creates a meeting of the state body. So what does it mean when you have a meeting? So when you know there's a meeting, when there's a majority of members of a state body, you have to have certain requirements under Bagley-Keene. And this is talking about notice of that meeting. So the rule is that there's 10 days notice of a meeting. The meetings have to be posted on the website. So we have on our website a list of all the board meetings, committee meetings, and they must be posted 10 days in advance. The notice has to include specific material on the agenda. The notice has to include the date, the time, the location of the meeting. It has to include a contact person for questions. Staff creates the agenda, so you as members really don't have to worry too much about that. However, what you should know is that only items on the agenda can be discussed. There's very specific exceptions for that if you want to add something to the agenda. So that means you have to stick to what's on the agenda, and that's really important, because if you don't, the public can say, I didn't have notice you were discussing this. The meetings have to be ADA compliant. Obviously, now that we're doing things via Zoom, it's a little bit less of a concern. Before, when we were doing in-person meetings, they had to always be held at a place that was ADA compliant. During Zoom, we do, however, have to make accommodations if people request them under the ADA. So that's why on our notices, we say if someone needs it needs compliance under the ADA, such as if somebody needs visual assistance, they are to contact us to make arrangements. Meetings also have to have an opportunity for public comment. We'll talk about that in a little bit. And there are exceptions to these notice requirements for special or emergency meetings, meaning if the state body needs to meet for an emergency, has to make a decision right away, you can have a meeting in less than 10 days notice. So these are, I'm going to skip this one because this is mostly for staff. This is about, how to construct an agenda and what makes a good agenda item. Generally, they have to, make sure that the public has can understand from the item what is going to be discussed. So you want to say, make it clear the public knows what's going on at the meeting. And it's very important because the courts are very clear that, they have an expectation that that to go to this meeting and understand what's going to be discussed. These were just examples. I'm going to skip that. So adding items to the agenda. So as a member, you might say, oh, this thing came up. I really want to talk about it. However, the agenda has been posted. So there are occasions where you can add something to the agenda. Usually, obviously, the staff should be involved in that. Usually OGC, legal counsel is consulted, but there are exceptions to add something. So this would happen. The exceptions are on the slide where you can take a majority vote that there's an emergency situation, such as a crippling disaster. I put in a capitalization that it's very rare. However, as we know, we did have a pandemic that did create an emergency situation earlier last year. So it does happen. So there has to be a 2/3 vote of the members present that there is that emergency situation. And as well as there's both a need to take immediate action and the need for action came to the attention after the posting of the agenda. So it can't just be, I forgot, I meant to put it on the agenda, but I just didn't. That's not good enough. It has to be something that actually came to the attention that needs to be discussed after the meeting agenda has been posted. So a meeting does not have to occur in one place. So this is really important as members of a state bar committee, that when I said before that a meeting consists of a majority of members, that can be through a series of communications. So the biggest one is you can think of as email. So if you have an email discussion among committee members, that's a meeting. And under Bagley-Keene, it has to be noticed. So that means that you cannot have an email discussion among committee members, a majority of committee members, that might violate Bagley-Keene. So you can't have individual debates, discussions about anything that's in the jurisdiction of the committee. However, you can have you might have individual communications with staff. We'll go over that in a second. But I would say email is the most common one, but this also applies to telephone meetings. serial briefings. Usually, think about it whenever you're emailing or reply all, things like that. Those would be considered a meeting. So be very careful. We always advise with your emails and how you're using your emails. So these are, as I was just saying, these are called serial meetings. These are some examples. A daisy chain would be when you email one person and then the person emails another person and then they email another person, etc. So even though you're not all in one email chain, you could still be in violation of the Bagley-Keene Open Meeting Act because you are technically having a meeting with more than a majority of people. So when I say majority, if you're just communicating with one committee member about one thing, that's okay under the law. However, we say be careful with that because, you don't know when that person's going to communicate to somebody else and it could cause a violation. So generally just be cognizant of that when you email. Hub and spoke, that's a term when you are emailing, one person sends out an email and asks for recommendations, advice, things like that. And somebody gets individual replies. So you're a member and you're saying, what do you think about this proposal? And 3 different people reply to you. That could be a Bagley-Keene violation because it's technically a discussion. And there's been case law about that. So you should be careful with that as well. You shouldn't be individually soliciting different advice from different members. So we generally say avoid reply all. As you will see, staff, I don't know if they do so here, but often staff will BCC committee members to avoid a Bagley-Keene violation because it's very easy for someone to reply all. Don't include a quorum, which is the majority. That makes it a violation. Be careful with briefings, telephone calls. So this is the exception I mentioned before. You can have conversations with staff. You can, usually that's what we recommend when you do have some sort of question or you do want to get out information to everyone in the committee. You can email staff and say, hey, can you distribute this document or this PowerPoint? And they can do that. And that would not violate Bagley-Keene. However, obviously staff tries to make it BCC so that people don't reply all to that email. And if you have, if you're not sure if your email or your communication would violate Bagley-Keene, please just ask staff and they'll give you guidance on that. So these are also exceptions about communication. So as I was saying before, individual contacts between members of the body do not violate the act because it's not a majority, but still be careful. So you can also attend other conferences, trainings, workshops with the majority of committee members that wouldn't violate the act as long as you're careful not to discuss any business. Open and publicized meetings regarding a topic of state concern. Purely ceremonial, social occasions, that's fine too. Majority of members of a body can attend a meeting. We call these, they use the term standing committee in the statute, but that really applies to any other committees or commissions of the state bar. So if you want to attend a board meeting, obviously, a majority members of this committee can attend a board meeting. It would not violate Bagley-Keene as long as you're not participating in that meeting on behalf as a member of the committee. So these are teleconference meetings. A lot of this slide applied to the law before the pandemic, which is still the law. I mean, it's still the statute. And perhaps, I need to update this to take into account the pandemic. But prior to the pandemic, there was very strict requirements about teleconference meetings in the sense that if you were calling into a meeting, you had to list your address so that members of the public could come and actually go to wherever you called in. So usually, if you had somebody that wanted to call in from their home, they'd actually have to list the address of their home. Now, because of the pandemic, there was an emergency order by the governor that put those on hold that said, these are overridden due to the pandemic. So we no longer have to do that right now. At some point, that emergency order will be lifted and these requirements will come back. So I think it's important to know them because eventually, hopefully things will go back to normal. And in that sense, we hopefully will have, in-person meetings. And in that sense, if you did want to call in from somewhere else, you would have to list your call-in location. And that would also need to be posted on the agenda 10 days in advance of the meeting, and the location must be ADA accessible. So it's important to know that. Right now, obviously, you don't need to do that. You can just call in from your home. Also, the portion of the teleconference meeting must be audible to the public. So even though, technically we're not subject to the call-in location requirements, this meeting is technically considered a teleconference meeting, which means that we have to make sure that this meeting is audible to the public, that the public can hear it, the public can participate if they want to, and that votes are taken by roll call. So it is technically, because it's not in person, it meets the definition of a teleconference meeting. So this is back what I was saying about the requirements if we did have to post the location on the agenda. And it talks about how you have to give that location at least 10 days in advance of the teleconference. And if one member is attending by a teleconference, that meeting is converted into a teleconference. The last question is, what do I do if you are unable to notice your home or address? The answer is, oh, I didn't have the answer, but I will tell you the answer. The answer is under the, before the emergency, you just couldn't attend the meeting. So if you said, I don't want people coming to my home, but you still wanted to call in from the home, unfortunately, you couldn't. I mean, you could still call in and listen, but then you couldn't participate. I know it's a little outdated. The law is not really up to date with technology, but that's what the law says. Oh, I did have the answer. I'm sorry, I missed that. Yes, members must either attend another notice location or not participate. Bagley-Keene doesn't require posting a call-in number. For the teleconference, we would do so. These are out-of-state call-in locations. I'm just going to skip that because we're not really concerned about that right now. I'm not going to spend too much time on it, but if things go back to normal and you did want to call in from out of state, the chair would generally decide if that was permissible. This is just an overview of it. I think there's so many slides on this because we get a lot of questions about it and it is a little bit confusing. So I kind of emphasize the main points of this, that you can only listen in, you can't make comments, you can't vote, things like that if you don't have your location posted. Again, not relevant right now. So this is public comment. So at each meeting, every state body has to provide an opportunity for members of the public to address the state body at each item on the agenda. So that means that it has to be before you talk about whatever items on the agenda. Usually, we have a set period of time at the beginning of the meeting for public comment. But however, that can always be taken. If someone's late, you can always decide, oh, they missed it. It's really up to the chair to decide how they want to address the public comment. Public comment's not required if it's the same item was already considered at a prior meeting. You can also adopt reasonable regulations to govern public comment, including limiting the time for speakers. So if you know you're going to get a lot of public comments, you can say, we're going to limit the public comment period for only an hour. And that means that you can cut it off. There might be other people that might want to talk, but you can just say, oh no, we're limiting it to an hour. You can give people 2 minutes. That's often what the board might do. If there's a lot, they might say, okay, we're just going to give everyone 2 minutes to talk. And also sometimes people might keep going, but you can say, no, you're cut off after 2 minutes. It just has to be reasonable. So just keep that in mind. It has to be fair for everyone. So you can't give one person 10 minutes and one person 2 minutes. Members of the public can record the meeting, so that's okay, but they can't cause a disruption. So there have been times on Zoom where someone will, Zoom bomb or, the word for, yelling things during the meeting. That's not okay, and that can even cause the meeting to end if there's a lot of disruption. This is social media. Now we have a lot of, Facebook pages, Twitter, things like that. We always just advise to be wary on your social media use for inadvertent Bagley-Keene violations. So for instance, if you like a comment about an issue the state bar is discussing or considering that's in the jurisdiction of your committee, you should be careful because somebody else might like it, someone else might comment on it, and that might create an inadvertent meeting if there's more than a majority. So just be careful when you're posting on social media. Really think about what you're doing as a member of the committee and how that might potentially violate Bagley-Keene. Closed session meetings are not open to the public. So as I said, we have this idea, we want transparency. We want people to participate, but obviously there's going to be things that are not appropriate for the public to listen to. And those are specifically prescribed in either the Bagley-Keene Open Meeting Act or state law. By state law, that's we are governed by the State Bar Act, which is in the Business and Professions Code. So we have a few things in the State Bar Act that apply specifically to the state bar that allow us to have closed session. Closed session must be held during a regular or special meeting. When I say they cannot be scheduled independently, that means that it has to be noticed the same way any meeting would be noticed. So that means if it's only a closed session, and there's nothing to talk about, you still have to post an agenda. You still have to list what is going to be discussed the same way it would be in open session. Often there's usually, for many meetings, for most meetings, I think, there's usually both an open and closed session, and then that's listed on one agenda. The agenda must indicate the specific grounds for closed session, so you have to actually cite the statutory basis for that closed session. So I'm not going to go through all of these. These are the closed session grounds under Bagley-Keene. These are common ones. It's about appointment of an employee, grading and administer an exam. So that's usually applicable to the bar exam, certain unwarranted invasions of privacy, certain lease negotiations. Usually, staff will make the determination whether something is appropriate for closed session. So, and they'll put that on the agenda as closed. These are continuations, certain matters posing criminal or terrorist threats, advice of counsel regarding litigation, and also to discuss draft audit reports. This isn't all of them. These are just the ones that most commonly apply to the state bar. These are the closed session grounds under the Business and Professions Code. These probably aren't going to be applicable to this committee. This is mainly for the Committee of Bar Examiners regarding appeals from Board of Legal Specialization decisions, grade approval grading of the bar exam, moral character, and information regarding law schools, trade secrets. So that's closed session. So then I mentioned there were some exceptions for emergency and special meetings. These are rare. Usually, general counsel is involved to make sure requirements are met. For special meetings, they can be held within 48 hours. It's very limited. The statute provides specific basis for special meetings. It also requires that posting would cause a substantial hardship or that immediate action is required to protect the public. I know I mentioned before that there was the immediate action if you add something to the agenda. So this is different. This is when there is no agenda at all. There's not been a scheduled meeting and you want to have a meeting. So it's a little different. Emergency meetings are when there's even less notice. That would be when you have 1 hour notice. This is extremely rare. There has to be a work stoppage that severely impacts the public health or safety or a crippling disaster. While I say it's rare, we did have, the need to have these when we first had the shelter in place in early 2020. Open meetings and writings. This is an overlap a little bit with the CPRA, but it does apply to Bagley-Keene that the public has the right of access to records of the state body. So what we do is we post material online 5 days in advance of the meeting. So we post the agenda items. However, things might not be posted that are discussed, such as something like this PowerPoint. The public would have a right to that because it was something that was discussed at the meeting. The public has a right of access to any other writings or materials that are distributed to the state body. So that means if somebody gave out written materials or an email, it doesn't necessarily need to be posted online for it to be public. It might not be made publicly available if it falls under an exemption under the California Public Records Act, which we'll talk about when we talk about the CPRA. So that means, obviously, if you're going to get, for instance, privileged material, things that are confidential, obviously that does not need to be disclosed. But if this just goes to the statute, specifies the timing of disclosure. So if prepared by the state body, it has to be made available at the meeting. So that means they either need to be able to get it online, or they need to be able to either ask a staff member, hey, I want to see this document that was created by the state body. If prepared by another person, including state bar staff, because state bar staff is not a member of the body, they can be made available after the meeting. So if someone requests a record, staff will then give it to them afterwards. I just said that includes right of access to PowerPoint. There could also be access to emails and writings between members, as well as search history. So just generally, we always say be careful what you're doing during the meeting, because the public could say, I want to know what this member was doing during the meeting, and we'd have to disclose that information, subject, of course, to any confidentiality or exceptions under the Public Records Act. So then one common misconception is that when you're in closed session and you have a document being discussed, it's automatically exempt. That's not true. If the document is otherwise falls within something that needs to be publicly disclosed, it still needs to be disclosed. It doesn't matter that it was discussed in closed session. So just keep that in mind when you are discussing, when you have written materials. Each document has to be individually analyzed to determine whether it should be publicly disclosed. Some closed session grounds do overlap with CPRA. So for instance, if you're having a closed session to discuss litigation, a document that you're discussing might also be exempt from disclosure. So the fact that a document concerns something appropriate for closed session will likely support why you want to not disclose it. But this is mostly for staff to make that determination. You as a committee member wouldn't make that determination anyway, but we thought it was important just to know that. Audio tapes, video recordings of the meeting are subject to inspection. They can be erased or destroyed after 30 days. So that means that if there is a recording of this meeting and somebody does request it, it would need to be disclosed. Closed session minute book is not subject to disclosure. So under closed session, the minutes do have to be kept. However, those are confidential under the law. So this is the end of towards the end of the PowerPoint for Bagley-Keene. These are just remedies, and these are things that happens when we don't comply. And there are a lot of requirements, as I just said. There are a lot of technical requirements. So what can happen is a member of the public can bring an action to overturn a decision that was made at the meeting. So let's say you don't give, the notice is bad, or you don't properly describe something. The member of the public can actually say, I want to undo whatever action was taken, and that's a remedy they're entitled to get. The court of public opinion means that, we can have an article written about us that says, the state bar didn't comply with Bagley-Keene. We don't want to come across as not being compliant with the law. Civil action, as I said, when they do make this action to overturn a decision.
Suzanne?
Yeah.
I'm going to jump in here quickly just to say we have gone over time. So let's assume we will be compliant and
we can skip that. Okay, sorry. Sorry. And CPRA is really short. In fact, I can just summarize this very quickly in this. The big takeaway, it's only a few pages, is that, and I can give this PowerPoint to anyone that needs it, is that just know all your emails could be subject to the California Public Records Act as committee members of a committee of the state bar. So keep that in mind when you're emailing. We suggest making a separate, you can get a state bar email if you want, or segregating your emails for a state bar business. So that's the main takeaway with CPRA, that any writing, which is emails, text messages, phone calls, anything involving the state bar could be subject to public disclosure. And if we do get a public records request, we will ask you to search your emails or your records. And for potential production, as I stated, they're not always going to be produced. There are exemptions, confidentiality, things like that. So that's the big takeaway for CPRA. So yeah, sorry, I did go over time, but that's all in the PowerPoint, and I think staff has it. Lauren, I give it to Lauren, can distribute it. Does anyone have any questions?
I think it has been distributed and it's in the meeting materials that we all have access to. So that's helpful. Sorry to rush you at the end there.
Oh, no, that's okay. I know it's a lot of detail in here. So my apologies. And I hope I didn't talk too quickly. I do talk fast, but hopefully that all made sense and that the PowerPoint is in the materials.
We have the resource to double check.
Great.
Thank you, Suzanne.
Thank you. Have a great rest of the day. Bye.
You too. Bye-bye.
So, Teresa Ruano, you are up next.
Good morning, good afternoon, good evening. Can everybody hear me?
Yes.
My little bit of this is going to be very brief because I'm feeling like you're probably needing a break pretty soon. It's really a follow-on to what Suzanne has talked about in terms of the Open Meetings Act and public records. It has to do with this committee's work and how it will generate interest within the media, and also a little bit more about social media guidelines. I know that you have the materials related to that, and Suzanne brought it up in her presentation. In general, the media policy for the State Bar, and this applies to the Board of Trustees and all of the committees, commissions, working groups that volunteer to provide their expertise to the Board of Trustees, is that we follow a best practice, and that is that media inquiries are coordinated with staff. So given the size and the caliber and the already established relationships and platforms that I know many of you have with the media, you will get direct questions from the media. What we ask of you is that you forward those to your committee staff and work with my office to kind of highlight key messages, to coordinate how we might respond to that inquiry, whether it will be something that you yourself will need to provide commentary on, or whether it's something that we as State Bar staff can respond factually to. There's kind of a range of those opportunities. And I know that one of the things that will come up, there will be, I believe, proactive opportunities. I liked Marta Alkenbrack's comment that this was going to generate a dynamic and interesting conversation. That's certainly true within the context of your meetings and discussions. It's going to be true within the media. We've already had members of the legal profession commenting on the work of the group, and it hadn't even had its first meeting yet. So we do hope to take advantage of the expertise and the perspectives, the kind of the interesting blend of the nexus of these topics, and make some of the work visible within the media. But I know that you all would agree with the idea that we need to give this group a chance to actually do its work together. And that's the most important focus, I think, of the media policy, and why we ask that if you get inquiries, that you work with staff and work with my office. The other point that I just want to make has to do with your presence on social media and the discussions that will arise within social media with members of the profession, with other interested stakeholders. The Bagley-Keene requirements that you be careful about how you present your views and how you perhaps engage in discussions on social media, particularly when other members of the working group are also in those discussions. It's very important to keep in mind your obligations under Bagley-Keene. That is why we created those social media guidelines that create sort of the do's and don'ts, the specifics. And again, if you have questions or if you become aware of a discussion on social media that perhaps staff may not be aware of, we really encourage you to work with your working group staff and involve us if it's needed. I think that that in the past there have been very active discussions for ADDLs. ADDLs had a hashtag, and somehow that was helpful. We haven't talked yet about what the hashtag will be for this working group. But again, I think that the discussions are already occurring in social media around access to justice, and the efforts that I know you'll be hearing about in these presentations later today. That's going to continue. And if there's ever any time when you want advice, my suggestion is that you start with your staff and they will involve my office as needed. That's all I wanted to say. I'm really excited about the work that you're doing. I'm so impressed with the collection of people, and I look forward to working with you. Thanks.
Thank you, Teresa. We look forward to working with you, and I appreciate the reminder that we all need to keep you in the loop. Appreciate your support with our efforts. I think, Randy, on administrative matters, the third item on our agenda here, you have some comments. Is that correct?
Yes, I'll go very quickly. Lauren, if you could jump right to, I think it's the other administrative matters slide. We have established, in follow-up to what Suzanne Grant explained in terms of the responsibilities with regard to the California Public Records Act, we have created an email inbox for all of the emails that you will send in connection with your work on the working group. That email address is ctjg, closing the justice gap, at calbar.ca.gov is the email address. And we ask that all of the emails that you send be copied to that address, as that will be our aggregate repository for all of those messages, should there be a situation where we have to produce them. We also ask that you maintain good communication with staff on all the basic information that's listed on the screen in terms of your status in attending the meetings. If you have some last minute obstacle or delay, if you let staff know, then in advance of the meeting, and as soon as you know, then we won't be looking for you when we call the roll call, or if you have an agenda item listed. We also need to know the status of assignments and agenda materials that will be posted for the agenda. Suzanne mentioned the 10-day notice requirement for the agenda document itself. And the agenda materials can come a little bit later, but not too much later. But if you're on a subcommittee or you're on a working group of, say, 2 people that Suzanne mentioned, and you have something that will be on the agenda for the next meeting, please keep us informed as to when we can expect that, because we do have to remediate it for ADA compliance, and that takes some time in some cases. And all of you are probably Zoom veterans now, so indulge me if I'm going to repeat things that you already know. But our meetings will be established as Zoom webinars as opposed to Zoom meetings. And that's in part to promote Zoom security. But the webinar system means that you will be receiving a dedicated link to sign into the meeting that immediately establishes your participation status as a panelist and gives you access to your microphone and your cameras as soon as the meeting begins. For those folks who are attending using the public access, we have a raise hand function that you can use to indicate that you'd like to speak. And the webinar host in most cases will be Mimi Lee, and she will be monitoring that. And particularly at the beginning of the meeting, we will put into a queue all the folks from the public who wish to speak. In-person meetings was mentioned also by Suzanne. And I won't say anything other than in your appointment letter, you received the State Bar's travel policy, expense reimbursement policy. And so if we ever get to in-person meetings, we'll talk about it more before it happens. The meeting schedule, and I'll pass the baton to Lauren just to give us some tentative dates for, I think, February.
Okay, sorry about that, guys. I was being distracted by another communication. The dates that we have arrived at, subject to having a quorum of the rest of the members. For the February meeting, we're tentatively looking at February 19th. And for April, because there will be a break, it'll be every other month for the first few months, or first portion of the year, for April 9th. So we will be reaching out to you via email and asking that you respond and let us know if you have any immovable conflicts that we need to consider and whether or not we have a quorum. But those were the best dates for the leadership and staff teams. So we'll be in touch soon.
Last thing I'll mention, just as sort of a housekeeping, is that we have established a file sharing cloud storage drive. It is a OneDrive, and the URL for that location is on the screen right now. We can probably send it out as a link as well by email after the meeting, but we will be posting there any background materials, resources such as the travel policy, the roster, the agenda materials can also be maintained there for one-stop access. We ask that you don't use it though for actual collaboration because of the Bagley-Keene issues. If you want to collaborate on documents, Suzanne mentioned, send anything you want distributed to any of your colleagues, whether it's one person or more than one person, such as a subcommittee. We'll talk about that later. Send it to staff and staff will turn it around. We may use email, we may use the drive as a place to distribute it, but going through staff is the best practice, but for your individual sort of research and background and as a resource for you, the OneDrive is there for you to find all of the documents related to the working group. And that's all I have for the staff housekeeping.
Thank you, Randy. Let me do a quick note of housekeeping. We're going to take a break now for a few minutes, just 3 or 4 minutes, 3 to 5 minutes, and come back to hear the 4 presentations that we have that are sort of the bulk of today's meeting time. But we're going to swap the order there because we have Crispin Passmore currently listed as the 3rd meeting, as the 3rd presentation. We're going to ask him to go first so that he can give us his presentation. Then we're going to take a lunch break, not a very long one, but just a half hour so everybody can take a break, do things you have to do, and get some food, which you are welcome to bring back so that when Professor Sandifer gives us the 2nd presentation, it can be working lunch for those of you who want to eat while you listen. So quick break now. We'll come back in 3 or 4 minutes to hear Crispin Passmore. Then we'll take our half-hour lunch break. Thanks, everybody. We're in recess. Ask people to hold their questions until the presenter has had a chance to run through the material so that we can then have fulsome discussion all at once after the presentation. With that, you all have met Crispin Passmore. We're privileged to be able to hear from him and his work in the UK. Take it away.
Thank you very much, Alison. I'm just going to share my screen, hopefully. Yeah, I think you can see my screen. So I'm going to talk to you about regulation in England and Wales. I won't presume to tell you how to regulate in California, but hopefully I can provide some insight to you about the way that we've done it in England and Wales. I won't be trying to sell the version of regulation that we've got in England and Wales. It's far from perfect. And at times, even after 10 years of reform, in some areas, it's perhaps not even good enough. But I think overall, it's pro-consumer, it supports the rule of law and the proper administration of justice. And that seems to me to be the core things for a regulatory system of any profession or any market. So often the debate about England and Wales, and I'm going to talk about England and Wales, not Scotland and Northern Ireland. They have separate legal systems in the UK and separate regulatory systems. But England and Wales is where most of the interesting reforms have taken place. It's very different to US states. We've got no unauthorized practice of law process. And therefore, when people start talking in other jurisdictions about alternative business structures and regulatory reform, it's often misdirected by an incomplete understanding. It's not just like adding ABSs or non-lawyer ownership into the sorts of system that you have in California. It's most important really just to note how different our model is, even pre-reform. We've never had a UPL. Instead, we regulate a short list of activities that are reserved to people that are authorized to conduct those activities. And that means that most legal services can be delivered by anyone, subject only to consumer law and competition law that apply across all markets. And we don't just regulate individuals, we also require any firm that wants to deliver those reserved activities to be licensed as well and to be regulated. And that's everything from a solo lawyer in a firm right the way through to global law partnerships and all the new forms of non-lawyer ownership that we have in England and Wales. They're all licensed. Our solos, for example, may be the solo owner of a law firm practicing as the sole owner, but they might also employ lots of lawyers and paralegals. Some of our solos, for example, are quite significant businesses. So there's lots of different ways, lots of different types of lawyers in England and Wales. I'll focus predominantly on solicitors, because that's the largest area, but we have a mix of limited license and broad licenses similar to solicitors, perhaps in the same way as paraprofessionals and limited license practitioners in different US states, and something that I know California is also interested in. So what are the reserved activities that we do regulate? Well, you can read the list for yourselves, and it's worth noting that it's a criminal offence to undertake these activities when you're not licensed, either as an individual or as an entity, as a business. The courts tend to interpret them reasonably narrowly. Conducting litigation includes ancillary acts to issuing proceedings and defending those proceedings, but that doesn't mean that everything that's done around the periphery of litigation, such as due diligence, checks, disclosure management, all of those different things, evidence gathering, is covered within that. So they're quite narrow activities. There's a couple of areas, separate immigration and claims management, that are regulated in other ways. But the point really is that with a bit of imagination, it's possible to get around most of these and find ways to do them without breaching the law. Even things like conducting litigation and exercising a right of audience. A court has a power to let anybody appear in front of it. And whilst you can't conduct litigation, what you can do is help somebody conduct their own litigation, because people have got the right to take their own cases. So, for example, we have flexible lawyering platforms that rent out lawyers rather than give legal advice, much as you have in the US, and they're often US businesses like Axiom and others. I guess the point really for me is that just banning stuff like unauthorized practice of law doesn't really work in any markets. And that's perhaps why the most significant ABSs and unregulated legal businesses we have in the UK are actually US businesses, despite the unauthorized practice of law regime. It hasn't really kept these people out of the broader legal market in lots of ways. So as I say, we have lots of unregulated services that are not conducted by attorneys or law firms or even ABSs. We've had them for at least 150 years. So we've got quite a good track record of understanding the consequences of allowing just ordinary folk to deliver most legal services. It covers not just things like the sorts of areas that are on the screen at the moment, but actually probably 80 or 90% of legal services can be done by people that are not regulated lawyers. What's interesting is that the evidence tells us that we don't have any great problems in terms of consumer harm or damage in courts from these unregulated providers. So for those that are concerned about whether or not non-lawyer ownership of regulated law firms is a problem, what we can tell you is actually having no lawyer involvement in a business doesn't actually cause any significant difference in harm at all. But I know that what you're most interested in is what we regulate, and we can talk a little bit about the unregulated market as evidence for understanding change, but I'll try and focus particularly on the regulated parts of the legal market. So I said Solicitors Regulation Authority is where I used to work. I was exec director there. It's the biggest of the regulators, but there's actually multiple regulators of legal services in England, Wales, often grown out of the titles of different lawyers, attorneys that have grown up over a long period of time. Some over the last 30 or 40 years, some such as notaries go back to Henry VIII, the UK's break from Rome and the dissolution of the monasteries. That legislation from Henry VIII's time is still in place to regulate notaries in England and Wales. We haven't got around to modernising that yet. But we have a huge range of lawyers, but really what's interesting is how we regulate solicitors, because they're the large part of the legal market. As I said earlier, there's 200,000 solicitors. Not all of them practice, but they're on the roll as solicitors. And there's around 10,000 law firms. They're global law firms. There's US law firms, all sorts of different businesses. The bar is important as well, culturally and politically and at the very elite level. But actually, while barristers are known for the advocacy, in reality, solicitors do more advocacy than barristers in England and Wales. Perhaps the majority of barristers are doing pretty run-of-the-mill lawyering, but the elite really are elite trial lawyers and subject matter experts. SRA regulated firms do not have to be solicitor led, even though it's called the Solicitors Regulation Authority. It regulates entities that are owned with no solicitor involvement. It might be barristers, legal execs or others that are involved in it, and of course non-lawyers as well. But the SRA really is the main show. So a significant proportion of barristers, most legal executives, conveyancers, notaries are working in businesses that are regulated by the SRA. So as I said, there's 10 regulators. Independence of regulators really matters. I know that's an issue in different states in the US as well. The SRA is part of the Law Society, so part of our professional body, but it's statutorily independent from the professional body. This came about after legislation in 2007, the Legal Services Act. So we've got 10-year record really since that was switched on, that legislation of independent regulation. And it's fundamentally changed the debate. The SRA, whilst it's still formally part of the Law Society, it thinks like a regulator, not a profession. It's relentlessly focused on public interest and rule of law. It doesn't confuse lawyer interests with the public interest. Just as an aside, it always amazes me that the legal profession is never surprised that its own interests just seem to perfectly match the public interest when that means maintaining restrictions on competition. Aren't they the lucky ones? So regulators have to stick to a set of regulatory objectives that our Parliament has set out for them in giving them statutory functions. They must undertake their functions in a way that's consistent with these regulatory objectives. They're important because they provide a framework for thinking about how you tackle the policy issues that you have as a regulator. You know, what sort of barriers to entry do you have? How do you balance, you know, the ever difficult issue in most markets of quality and access? How do you design a system that doesn't pursue perfect protection for the consumers that get in to get services, but how do you design a system that provides good access for enough people at good enough quality? You know, professions inevitably pursue the very highest quality, but actually what we're interested in as public interest regulators, I think, is how do we get broad access as well as good enough? We'll leave it to the market to deliver excellence beyond good enough. And for law, good enough is obviously a high standard. But the independence of regulators set against these regulatory objectives also means that our Parliament and other agencies scrutinise the SRA and other regulators on behalf of the public. So getting back into detail of the regulated market, as I've said, since the Legal Services Act, we've had alternative business structures. These are law firms with non-lawyer ownership. It's not simply about getting a non-lawyer to put some money into a traditional law firm, which is, I think, what lots of people thought would happen when we first started talking about this 15, 16 years ago. It's actually about hugely varied models ranging from a husband or wife of a small firm being brought into ownership, often for tax reasons, often because they've been contributing to the business, right the way through to firms that are listed on the stock market, firms that are backed by private equity. You can see how varied they are even after 10 years and how significant in proportion they are across the market already. Probably around half of new firms that the SRA regulates each year are ABSs. Even firms that people would recognise as traditional law firms, when you scratch the surface and actually look, they're an ABS. You know, Reed Smith being an example, significant US law firm, it's an ABS with non-lawyer ownership. They've managed to, you know, settle the moral and ethical dilemma of it being unethical in US states with it being perfectly ethical to do it in the UK. Well, it can't be both ethical and unethical at the same time. And what we know is that, you know, they still deliver ethical legal services day in, day out to their clients. So, you know, often asked over the last 10 years, in 15 years in this, when I'm talking to other jurisdictions, what do I think about whether other jurisdictions can do this? Last couple of years, I've tried to encourage other jurisdictions to do this. I used to say, well, it's up to you, but the longer you take, the better it is for England and Wales in terms of investment into our legal market and growth and innovation in our market. But obviously I've changed my position now and I want all sorts of jurisdictions to think of new ways of delivering services. So how does the SRA regulate these firms? Well, it does its very best to regulate ABSs in the same way as it would regulate a traditional law firm partnership. It tries to regulate a solicitor individually in the same way wherever and however they practice, whether that's in-house, in a not-for-profit, in a government agency, in a traditional law firm, or in an ABS. In recent times, there's been further reforms that have tried to, you know, increase the ethical focus of regulation. So there's now a separate code of conduct for individual solicitors. It's just 7 pages. It would be recognisable, broadly speaking, to lawyers in any jurisdiction. And actually, I think it would probably be recognisable to professionals in any profession in terms of what it expects of people. There's some specific stuff for lawyers, of course, but actually I think it's about capturing just public interest, professional behaviour. And of course, we have a code of conduct for our firms as well. Legislation creates some differences between ABSs and other sorts of law firms, but they're not really important. They're simply because of the way that legislation was passed and the different times that it was passed in. Some of our legislation goes back 50 or 60 years for lawyers, goes back several hundred years for some other parts of our legal profession. But the SRA treats them all the same wherever it can. We have some particular obligations on firms, indemnity insurance and things like that. But what I'll just pause on for a minute is our independent redress system for consumer complaints. This is for individual consumers and small and micro businesses. Instead of complaining using consumer law, if they feel that they've not been well treated, they can go to what we call a legal ombudsman. We have lots of ombudsmen in the UK in most of our regulated markets, our utilities, our professions, lots of our public services as well. And they're independent, separate to the court system. They don't create case precedent, they're not bound by case law, and they're meant to make fair decisions in all the circumstances. And they deal with issues like poor customer service. The lawyer's not answering my calls. He told me he would charge me $1,000, he's charged me $2,000. You know, so resolving those sorts of low-level issues that shouldn't be professional misconduct, and unless they're, of course, very serious or repeated, but they're the sorts of things that actually customers get really irate about, and they can clog up regulatory systems. Regulatory systems aren't great at handling those sorts of issues because it gets looked at as a professional misconduct issue. Actually, ombudsmen just step in and try and provide a simple way of resolving those complaints, a mixture of informal, alternative dispute resolution and more formal adjudication where necessary. So how do we allow an ABS into the market? How would we allow non-lawyers, whether it's an individual that wants to join their husband or wife in a law firm, or private equity to invest in a law firm and buy a law firm, how do they get a license in England and Wales? Well, in lots of ways, it's the same as regular law firms get their license. They need to be authorised, and the individual owners, managers, partners need to be approved. If they're lawyers, or if they're solicitors, or other sorts of lawyers, that can be done reasonably simply. If it's the first time they're known to the regulator, that can take a little bit more time. And it's checking things that are reasonably predictable. You know, are they a bankrupt? Have they got a strong track record in their profession, if they're in a profession, or in business, if they're in business? Good character and suitability, criminal records, all the sorts of things that I'm sure you would check for lawyers. Who do we try and look at? We try not to go too far into this. I think when we started looking at alternative business structures, we tended to try and approve everyone that could be involved in a firm. So if we were looking at, for example, a global professional services firm, we'd have been tempted to try and authorize 10,000 partners of a Big Four accountancy firm across the world. Well, obviously that's impractical. Probably 9,950 of them don't even know they've got an office in England, let alone that it's setting up a law firm within it as well. So trying to get at people who have got a real influence or control across that alternative business structure. We're looking for people that can influence the way the business delivers legal services so that they understand the ethical obligations of doing that in terms of public interest in the rule of law and proper administration of justice. We have designated compliance officers, one for legal practice and one for finance and accounts. We'll make sure these slides are available in the shared folder that Randy was mentioning earlier, because there's links to some of these things where people can find out a little bit more as well. But really the key, I think, is that we try to do this in a way that is proportionate to risk, and I'll talk a bit more about risk. It doesn't take too long. I think at first it was taking the SRA a year to license people. Nobody had done this sort of stuff before, but 8 years on, and the SRA usually approves people within a matter of weeks. They know what they're doing, they can spot the risks, and they can spot the issues. But the key really, I think, is to think in authorization is that regulators aren't great at spotting where things go wrong at the point of entry. Because if we look at where things go wrong, it's not actually tied to how people enter a market. It's usually things that happen much later, whether that's money problems, mental health problems, relationship problems, business problems, alcohol, drugs, all of those sorts of things where things go wrong that drive unethical behavior. And that isn't easily predicted at the point of entry. So pretending that we're capable of capturing future ethical conduct at the point of entry, I think we're probably kidding ourselves a little bit as regulators. But what we can do is we can stop known crooks entering the market. And that's really what we're trying to do, whether they're lawyers or whether they're non-lawyers. Okay, so we tended, as we've looked at our regulatory system, we've tried to accompany ABSs with changes to liberalise the legal market, to increase innovation, but also to strengthen professional standards at the same time. And we conceived of this really of thinking of our rules as either economics rules or ethics rules. Yeah, the economics rules are about restrictions on the way that people structure and practice. The ethic rules are about the way individuals and firms actually conduct themselves and behave. And our aim really has been to remove economic restrictions wherever we can, even to the point where we took a position in 2014 as a regulator that we would remove economic rules unless we could justify keeping them, which is quite a significant switch around for a regulator, because I'm sure most regulators say, we'll keep our rules as they are, we'll keep the restrictions we have in place unless we can prove it's safe to remove them. Well, it's almost impossible to prove it's safe for the future. What we need is just good economic analysis that allows us to think about incentives and disincentives, strong ethics rules and discipline to capture people that step outside that, and then we can confidently remove economic restrictions wherever possible. But our ethical rules through all of that remain, enhanced and certainly not diminished in any way. You've still got to uphold the rule of law. You've still got to act in the best interests of your clients. Okay, I've mentioned a little bit about treating ABSs and other law firms the same. Increasingly, they look the same from the outside. People don't recognize whether they're going to a law firm or an ABS. Most people just don't care. What they want to know is the lawyer competent and experienced for what they want done and the right level of experience and expertise, and is the fee acceptable? That's what really counts, and that's about innovation in delivery, ways of delivering the service. Most people assume that the lawyers know what they're doing. I don't really think that having the core knowledge to do what you do as a lawyer really cuts it anymore. That's just the baseline to be able to go and play in the market. What we've seen, and I'll talk a bit about impacts of ABSs in a bit, is that, as I said earlier, the risks of unethical practice are not really driven by whether there's non-lawyer ownership or only lawyers in the ownership. Our experience as a regulator has shown us that the sorts of things that drive bad behavior or lead to bad behavior are certain types of work, handling client money and huge amounts of client money, struggling performance of a firm, unrelated bad business decisions. We've seen firms go under because they bought flash new property at the wrong point in the cycle and things like that. And sometimes personal ethics of individuals, but it isn't really something that you can link back to ownership. And when we think about that, it's not really any surprise. It's a little bit odd, really, I think, for 200,000 lawyers in England and Wales to think that somehow their morals and ethics are better than 65 million other people. I'm not really sure where they get off on thinking that, to be honest. Okay, so just to briefly touch on what's the impact of all of this. Well, I could give you my view of the impact, but I think it's better to look at independent evaluation of the SRA. I think ABSs are good. I'll let you just pause to read this. I don't think I really need to add anything to it other than to say you can take confidence that this isn't about big bang. Change takes time. We're 10 years on and it's still early indications of improvement. I think there's another 20 years to go in England and Wales before we really see all of the changes that flow from this in terms of the way the market operates playing through. And of course, these changes interplay with technology, changes in culture, obviously the effects of the pandemic, all sorts of other business things going on as well, financial crisis at the start of this for these sorts of changes as well. It's led particularly to improvements in innovation. These are no real surprise to me. I think if we think that the only way to the top of a law firm historically has been to start at the bottom and work your way up, gradually having every ounce of creativity and innovation crushed by a large organization. You know, it's no surprise that they all look the same and behave the same. If you bring people in at a senior level from other businesses and other markets, whether that's customer services, technology, product and service design, all of those different things, is it really any surprise that we see more innovation in ABSs than we do in other sorts of law firm? I would say, interestingly, since this research was done, I'm increasingly of the view that traditional law firms are responding to this, and it's led to more innovation in traditional law firms as well. I've not seen independent evaluation of that of any significant level, although there's a few bits from Oxford University that I think point towards that a little bit. But I take that as a really positive step as well. Here's some examples of the sorts of innovation. I'll just pause while you look at this. Personally, I find this quite a convincing argument for change. And perhaps also a convincing argument for the incremental element of this, that it's not about, you know, private equity coming in and blowing it all up. Actually, it's about just bringing experience, expertise, capital that allows for gradual changes in some area, some quite significant changes, but actually it takes quite a long time for this sort of change to happen. And there are all sorts of changes that traditional law firms can do as well. And I think we're seeing that as well, as I mentioned. I mentioned complaints handling earlier. It's been a big issue. It's one of the key drivers for reform in the UK 15 years ago was our politicians fed up with their time with their constituents, their public telling them how hard it was to complain against a lawyer, that lawyers were too busy looking after each other and themselves to deal with their complaints properly. Our Law Society had an awful track record of dealing with complaints at the time. So improvement in complaints handling has been, I think, a really important element of this. So, you know, we're pleased to see that ABSs, perhaps because of that expertise brought in from other markets, have shown some particular improvements in complaints handling. Just some final thoughts. As I said, 2014, the SRA published a policy statement that set out its rationale for its whole approach to reform post implementing ABS, shortening its rule book, liberalising its economic rules and strengthening its ethical rules. It's only a few pages long. It's worth a read. Some of it is very England and Wales specific, but I think the rationale transfers anywhere. We introduced a sandbox back in 2014, which I think was quite an innovative thing. It's still running and it's gradually evolving as the market evolves, and it's working increasingly with other organisations in financial services and government to stimulate innovation in the legal market as one of the government's priorities about innovation in professional services in England and Wales. Services is a huge part of our economy. It's a huge part of our global exports and one of the world's leaders on that. So further innovation is really important if England and Wales, as a relatively small country, is going to stay ahead in those areas. So we can't be satisfied with where we've got to. But I'd end really just by stressing that to me, this is all really pretty simple. As Becky will say, we've got an access to justice crisis for individuals and small businesses, I think across the world. I've yet to see a jurisdiction that hasn't got a very similar pattern of problems. And the evidence to me is clear that the current ways of regulating are not really working. We've built a legal market across the world that works well for lawyers, but not as well as it used to for lawyers, and it stifles their creativity and innovation. And if we can let lawyers compete and we can create a level playing field, then that seems to me to be a pretty important thing. I always think it's interesting that in England and Wales, some of our most significant examples are businesses from California. They're Rocket Lawyer and LegalZoom. They're businesses across the US, United Lex, Axiom, Elevate, and they're able to do things in England and Wales that they're not able to do in their home country and their home state. That's great for the citizens and the public and the business of England and Wales, but it seems a little bit odd in their home countries, particularly when, despite the restrictions, It hasn't stopped them existing, and it hasn't stopped them growing. Rocket Lawyer's got 20 million US adults have had an account with Rocket Lawyer. That's 20 million people that have had advice that looks quite a lot like legal advice. It satisfies a need that would otherwise go to a lawyer without breaching UPL. So the regime hasn't even protected lawyers from competition, but has perhaps made them complacent about the need to innovate. So thank you very much. Happy to take questions.
I'm sure people have questions, and I'm inclined to think people should just call them out. Unless someone wants to, okay, Wendy Chang has one. Start us off.
So you stated that there, despite the fact of not having UPL restrictions, that you're not finding a lot of victims. So what happens when you do find a victim? How does the system deal with that?
Okay, so they've got the same protections in consumer law as any consumer of a service does. So they can use alternative dispute resolution where that's available, or they can go to court, or they can use professional negligence insurance where it's in place. What's interesting, I think, is that despite huge amounts of research to try and find evidence that customers of unregulated legal businesses get poorer quality, nobody's yet found it. And interestingly, some of the research suggests that the patterns of advice are reasonably similar. So when people have done research looking at quality, there's two particular studies. There's one by Professor Moorhead that looked at a range of areas delivered, particularly at social welfare law services, so law for the poor. What they found was that the minimum level of quality was met reasonably equally by regulated lawyers and unregulated businesses, but excellence was more likely to be delivered by the unregulated businesses because they specialized in it. And then secondly, some research I commissioned nearly 10 years ago, shadow shopping. So we followed 100 customers that had already chosen who they were going to go to have a will written. Some were choosing an online service, some were choosing a unregulated business, some were choosing a law firm. What we found was that the types of mistakes differed between different parts of the market, but the level of quality was broadly the same. Wills were good enough equally on both sides in terms of delivering legally what the client wanted, whether it was regulated or unregulated. And we have quite a lot of consumer organisations in the UK. They don't get more complaints about unregulated legal businesses than they do about other parts of the economy, or more than they get about our regulated parts of the legal market.
This is Dan, very illuminating, thank you. As you probably know, doing pro bono is a fundamental ethic of practicing law in the United States, and is codified by the ABA and the vast majority of bar associations. Are you aware of any data showing how the change has impacted the provision of organized pro bono?
Well, I'm not. I will have a look around and see if I can find anything. We've got thriving pro bono here as well. To me, it's a core part of being a professional. But actually, we know that our private businesses are increasingly focused on corporate social responsibility as well. So I know that in the UK, businesses like Rocket Lawyer and LegalZoom have provided all sorts of pandemic-related pro bono services via their websites. And I know that lots of our law firms that are now ABSs continue their corporate social responsibility and their pro bono in exactly the same way as they did beforehand. It's good for the lawyers, it's good for their training often, and it's good for the businesses as well.
Thank you.
Can you give us some examples, Crispin, of the sorts of services that places like Rocket Lawyer and others can provide in the unregulated market and are providing in the unregulated market and can't provide at home?
Yeah, well, Rocket Lawyer and LegalZoom are both interesting because they have slightly different models. LegalZoom is now has an ABS in England and Wales, but before that it was able to deliver things like employment contracts and standard templates around contracts and basic letters, standard letters around disputes for employment or housing or commercial disputes, debt recovery, all sorts of things like that. They've now got an ABS, so they can deliver regulated legal services as well. Those they can do litigation and advocacy. Rocket Lawyer isn't an ABS. It's an unregulated business, but it's taken advantage of changes in the last couple of years to be able to employ attorneys, employ solicitors, and deliver all the legal services other than the reserved activities. So if you want advice about an employment contract or a merger of two businesses or selling a business, you can, commercial advice, you can get that commercial law service from Rocket Lawyer, from their solicitors on a fixed fee, not outsourced from Rocket Lawyer where they just introduce you to a lawyer, but actually you're contracting with Rocket Lawyer for those services, and they're using their staff attorneys and sometimes contractor attorneys to deliver that services. So short of litigation and going into court.
Thank you.
Hi, this is Reem Allos. Can you hear me?
Yes, yes.
Great. I wanted to ask you, in relations to modifying some of the rules of professional conduct, how were they modified in the areas of conflict of interest, as well as limiting the liability for these ABS organizations?
Okay, so the rules on those areas apply regardless of whether you're an ABS or a law firm. They apply in exactly the same way. It's a narrower conflict of interest rule in England and Wales than it is in the US. Our conflict rules broadly are, it's a bit more complicated than this, but to summarize them, you can act for someone where in all good conscience you can't do your best for them because of a conflict with somebody else. So you can act for two people who've got different interests, but you could, for example, act for two clients that have got broadly similar interests, even if they're not the same. It's not the same as in the US. It's a narrower conflict, and it's really about your existing clients. It's not about people you acted for 5 years ago and things like that. But it applies in exactly the same way for a traditional law firm partnership for Allen and Overy as it does for an ABS. So Elevate owns an ABS in the UK. It's exactly the same conflict rules.
Crispin,
I'm sorry.
Go ahead.
I'm sorry, the limitation of liability, did you cap the limitation of liability, or is it unlimited as it is?
No, it's broadly unlimited. There's minimum insurance requirements that are quite high. It's a minimum of 2 million on any one claim, but firms are also required to have adequate and appropriate insurance. So, it's not enough for a global law firm to get 2 million of cover. And they're required to some extent to disclose the level of insurance to their clients as well.
Thank you, appreciate that.
But we don't limit their liability. But accountants do, interestingly, perhaps because they agreed it long before competition rules got in place. It would be very hard for a law firm to do that now, I think, to limit their liability. Their clients wouldn't let them.
Crispin, thank you for a great presentation. When opponents of regulatory reform look at your experience in England and Wales, they tend to focus not on the absence of evidence of harm, but what they claim is an absence of evidence of improvement in access to justice. I know you would disagree with them on where the burden should be, but you had a slide where I think you said something about it, that the reforms have increased access to justice. Can you say something about that and give advice on how we might respond to those who say that there is no evidence of an increase in access to justice as a result of what you've done?
Okay, hi Jim. Yeah, tough question really, isn't it? Because how on earth do you really measure access to justice? And I think most economists, and yeah, we've got lots of them more expert in economics than me around the table, would probably say that if you liberalize a market, you would expect to grow it. And you would grow demand as well as grow supply, usually. So looking at unmet legal need is one measure, but I think personally not a hugely sophisticated measure, because the more accessible you make legal services, the more people will think they're a potential solution to the problem that they've got. So if you could deliver legal services for $1 a go, people that had a $5 dispute would think that that was a worthy investment. So, you know, lower prices increase demand. I think what we've got is we've got reasonable evidence of increased choice. So we've got different ways of delivering services, more online and those sorts of things. We've got reasonable evidence of a growth in the number of lawyers and law firms of all sorts. We've got reasonable evidence of more supply than most jurisdictions in small business and sort of middle class, ordinary working family sort of legal advice. Where I would be cautious is in solving the access problem for the very poorest. There's no amount of regulatory reform that makes somebody homeless suddenly have enough money to buy a lawyer. You know, so I don't pretend for 1 minute that we can solve the problems of extreme poverty just by reforming our regulatory system. But just to counter myself on that, what I would say is the fact that we've got a 150-year history of allowing legal services to be delivered to ordinary people outside of regulation is one of the reasons why we have a thriving not-for-profit sector delivering lawyer services, employing lawyers, delivering legal services at low cost and free of charge through law centres, advice agencies, and all sorts of other services as well. Where I would say the evidence is strongest is on small businesses, micro businesses, so an individual that trades as a plumber, a builder, those sorts of people. I think we've got reasonable evidence that they've got much better access to services than they ever had before.
Thank you.
Jit, would you like to speak?
Sure, thanks. Oh my God. You mentioned, Crispin, about not being able to, you know, at the beginning, at the entry level, about whether somebody's likely to cause harm. How have you gone about, especially with respect to ABSs, evaluating whether they are causing harm? Like, do you do audits, or, you know, what are the ways that you can look at whether there is consumer harm with respect to these entities?
So we're clear about what we're trying to check and what we're not trying to check. We're not trying to check if if it's a good business model in terms of will they attract lawyer clients and will they make money. That's their decision. We're trying to see whether or not they're fit and proper people to run a regulated legal business. So we're looking at things like criminal records, bankruptcy. We do worldwide credit checks. We do worldwide media checks. If they're from a foreign jurisdiction, we'll do a criminal records check in their own jurisdiction as well. And we get all sorts of disclosures from them as well, as individual owners and managers, and as the corporates that are involved in that as well. But we're realistic that, you know, if somebody from organised crime wants to run a law firm, it's unlikely to be Don Corleone that's going to put his name on the form. Let's be clear about that. He's going to find a compliant lawyer. So we don't think that we're going to stop that. That's about other ways of picking things up and being tough on enforcement. So I think as a regulator, you let people in unless you've got a good reason not to. And then you try and catch people before they do harm. And if they do harm, you make sure you're there first. You don't wait for other agencies and just wait for people to bring them to you. So the SRA works with huge data analytics. It works with data with multiple agencies, from police agencies, organised crime agencies, other regulators, financial services, the courts, both in data and unstructured information to identify risks in particular types of market, particular firms, and risks amongst individuals, to make sure it catches people before they do much harm. And it's increasingly sophisticated at that. So it uses artificial intelligence models, uses neural networks, all sorts of stuff to interrogate information, and then it targets all of its regulatory tools on the strength of that information. It doesn't do regular audits. Firms don't get a visit once every 5 years. Our experience is that's a waste of time. You spend a lot of time with people that are good. We want to leave those people alone, let them get on with running their law firm. We don't want to distract them for a week. We try and make sure that there's a little bit of randomness when we visit, just to keep people on their toes, but most of it is really quite smartly targeted.
So I'd like to follow up on something that Bridget just said. I was intrigued by your point, Crispin, when you said something along the lines of, lawyers think that their values and ethics are better than 65 million other people, and that just hasn't borne out. And so I just want to clarify that the ABSs, the non-lawyers engaged in these services, are held to the same. Are they subject to the same ethical requirements? And is the process for reviewing complaints about ethical conduct the same, whether or not it's a traditional law firm or an ABS?
So yes and no. It's broadly the same. There's some differences in enforcement because the legislation is different. So the law around lawyer-only partnerships goes back to 1974. The SRA can fine those lawyers and those firms £2,000. If it wants a bigger fine than that, it has to go to an independent tribunal. It can fine an ABS because the system is 2007 and it's built on our fairly modern regulatory system. It can fine an ABS up to £250 million. And it can fine an individual in that ABS, lawyer or non-lawyer, £50 million. Now that's obviously, we're not going to be bandying those sorts of fines around for most things, but it's got really strong enforcement powers. The entity is bound by exactly the same code of conduct for firms as a traditional law firm. The individuals that are non-lawyers, the lawyers are bound by the same code of conduct for individual lawyers wherever and however they practice. The non-lawyers are bound by most of the same code. So they're not bound by the bits for giving legal advice if they're not involved in giving legal advice, but they're still responsible as managers for the controls, the systems, the way the organization works. And sometimes one of the judgments as a regulator when you do entity regulation is when do you go after an entity and when do you go after the senior managers in the entity. Often you go for both. What you don't do is let them off the hook by just going for the entity because they'll close it down and that's the end of the party. So yeah, you have to behave in the same way as financial services regulators and telecoms regulators and things like that, I think, in that level of sophistication. But yeah, the non-lawyers are held to the same standards. That's the bottom line.
Thank you.
Justice Tucker, it looks like that satisfies at least the raised hands amongst the working group members. But we do have one raised hand from our one guest attendee.
Okay.
Sorry to cut in. David Engstrom, I think, just raised his hand. Just want to alert you to that.
Of course, go ahead.
Hi, sorry, that was an 11th hour hand raising. So Crispin, thanks. This was really interesting. I have two questions. One is pretty small and fact-based, and then the other is more open-ended. So the small one is, I'm wondering what the throughput is for this oversight for the Legal Services Board. They're the ones who are essentially licensing ABS structures. Am I right about that?
No, they license the regulator. So the SRA licenses ABSs. The LSB is there to keep them honest as the SRA. The LSB really has set the policy for the market.
So the regulator that is allowing ABSs into the system, like how much throughput is there? There are 1,400 you mentioned. I assume that's in the current moment, but how many are turned away? Like what percentage of folks come here to try to come to the regulator trying to qualify for this status, but then are turned away? How discriminating?
Not many. Not many get a no, because they tend to either, most of them, if they're doing it on their own, then they come and have a discussion with the regulator and say what they want to do, and the regulator will be open and honest and constructive with them. And then people that wouldn't be able to build something compliant go away. They don't make an application. Lots of them employ compliance consultants that will help them with an application, and that will help them make it compliant. So I've got somebody that works for me that helps firms do that sort of stuff. And there's lots of them around. So there's not a huge number that turned away. Sometimes you get individuals that are pushed out of a structure after discussion because they wouldn't be approved. And so the business will decide that they won't be part of the ABS. But it tends to be done in discussion. I can think of some examples that have been refused, but there really are not many.
All right, so then the open-ended question, and this is just so I think we can all start thinking about this a little bit, but you've painted a really rosy portrait of this whole process. And I guess I'm wondering like what the hitch has been, right? Where have the hiccups been in setting up this regulatory process? And that could be problems that persist that folks are thinking about in the here and now, but it could also be maybe wrong turns that had to be adjusted along the way, you know, and missteps that maybe California could try to avoid if it were to set up something similar.
Yeah, great question, Dave. I would say there's a few. One is culture, culture in the regulator and culture in the legal market. I'm amazed how cautious people are. So even now, when I work as a consultant, as I said, to legal businesses, when I help them think about their strategy in the legal market, I'm amazed how cautious people are across the market, ABSs, traditional law firms, etc. And they are seeking permission. There's a culture across law of seeking permission to do anything, which seems odd given that they make their money out of advising other people how to do stuff. So how you change culture seems to me to be a really interesting challenge for a regulator. You can allow any sort of innovation, but if people are scared of it, they won't do it. And that means you've got to get the culture right in the regulator as well. So you've got to say, not just we've changed the rules, but we mean it and we're open for business. And that leads, I think, to the second thing we got horribly wrong, of we were overcautious in the way that we checked people at the beginning. So as I said, we were taking a year to approve businesses. We were going up multiple layers of ownership to investors, 5 layers back in private equity that certainly didn't have any influence, didn't even know that the fund they were invested in was trying to buy into a legal services business. You know, all sorts of things like that with hindsight we just got wrong, and that rebuilt the culture of we're not really open for business even though we've allowed it. And that, I think, then leads to how you do this. If California decided to do something like this, it will obviously meet opposition. And the easiest way to deal with that opposition is to put in an extra rule here, an extra rule there, that signals that, well, we'll make it really hard for those people. Well, that will mean they just won't come. You know, so you can end up with an overly complex structure that really sends a signal to the market that you're not open for business. And that, I think, is an important thing. So yeah, culture, same as any change program.
If I can ask on behalf of Stephanie Bond, who's typed a question into our Q&A, what may be the last question for you today, Crispin. Are lawyers starting to see the value of ABSs in terms of helping free up their own time to devote to advanced lawyer work?
Yeah, so I think of one top 20 law firm, so a global law firm that I know very well. They have increasingly grown non-lawyer services. They're a traditional law firm partnership, big, global. and they increasingly deliver consultancy services, all sorts of other professional services that are adjunct to law. So they've grown their offer to their clients in response to watching the big four accountancy firms and some of the others, as well as their own creativity being let go. What's been interesting is that not only have they done that and innovated, but they're increasingly talking now internally in their senior team about, well, don't we need to become an ABS? Because if we're not an ABS, what we're saying is our lawyers are more important than our non-lawyers. And even the concept of non-lawyers in a multi-professional, multidisciplinary organization, to say that this profession is more important than these others seems a little bit out of date to them. And they're recognizing that, they need to see themselves as a business and have multiple talent at the top of the organization. An ABS structure allows them to do that. So, that's just one example, but I think it's happening more and more. So, David Clementi, who did the review that started all of this, put a fabulous line in his report back in 2004. He said, to lawyers that say they're not in business, I say, well, wake up soon or you won't be.
Well, thank you for ending us with a humorous line. We're going to take our lunch break now. We're going to come back at 1:25, which I know is an odd time, but I don't want to make it any longer than that because we're running late. So we'll see everybody at 1:25 to hear from Professor Sandifer. Thank you. Bye-bye. I see a lot of faces and some black screens. Oh, now everybody's reappearing. That's awesome. Thank you. And for those of you who are still eating behind black screens with your names on it, that works fine too. I'm sorry that our lunch break was so abbreviated. And I know we're all looking forward to hearing from Becky. So I will turn the screen over to her.
Thank you. Welcome back, everybody. I'm going to try to economize a little bit because Crispin has kindly done some of my work for me, although now I cannot find the file that I need here. My job today is to talk about the problem that we're trying to solve and some of the insights we have on a consumer perspective on that problem. Let's see, here we go. So hopefully you can all see this. So I'm going to talk about evidence about the justice gap in the United States and some of the different forces that are creating it and why some of the ideas that we're thinking about could be responses to that problem. So I want to talk about what we know about the access to civil justice crisis in the US. I want to talk about the evidence that tells us that if we had more kinds of helpers, people might get more help. And then I want to talk about the evidence that tells us that those helpers might be effective in providing that kind of help, because why would you want to give people help that doesn't actually help them? So what do we know about the access to justice crisis in the United States? Well, depending on who you talk to, they define that crisis somewhat differently. So one way it's discussed is from the perspective of courts, so that you have, in some instances, 90 or 98% of parties to some kinds of cases, family cases, debt cases, landlord-tenant cases, appearing with no assistance. So this sort of wave of unrepresented litigants. Another way people talk about the access to justice crisis is being able to get your case heard. So courts and this is something that's going to be a big deal once the moratoria on debt and eviction end. There will be enormous backlogs of cases that courts will have to figure out how to handle. So that's another way of thinking about the justice gap. A third way of thinking about it is as the enormous number of people who face civil justice problems that can affect their livelihood, their shelter, their ability to care for people who are dependent on them, and they get no assistance with that. So typically people either, when they refer to the justice gap, mean all those folks showing up in court with no help, or all those folks facing potentially life-altering problems with no help. The way we know about this, because most problems don't make it to court, is by asking people directly about their experiences. And over the past 20 or 30 years, there's developed a lot of expertise in how to do that through what are called justiciable problem surveys. So you don't ask people about legal issues, but you ask them about specific situations. So you don't say, tell me about your wage theft problem. You say, does your employer owe you wages he's not paying? Are you behind on your rent and therefore it turns out, in violation of your agreement and at risk of eviction. The reason that you ask questions in that way is that it enables people to report faithfully about the problems that they're having without having to know a lot about the law. So you ask people, do you have this particular situation? And then you can ask them how they tried to resolve it and how it affected them and so on. And this is part of a move towards people-centered access to justice. So around the country, court systems are beginning to think in this way. Legislatures designing court systems are beginning to think in this way. And it's also a big part of Sustainable Development Goal 16, which says people have to be able to have the protection of laws to enjoy the benefits of economic development. So this is a sort of a general trend around the world with a lot of examples and a lot of expertise. And if you look at the data we have for the United States, what you see is that the numbers I'm going to show you are conservative. People experience all kinds of justice problems throughout their lives. They experience them at high rates, and they happen in core areas of life. So the World Justice Project did a survey that represents the US in 2018. You got 30% of people with consumer issues. You've got over 30% of people reporting housing issues. You've got 37% of people reporting issues with money and debt. So very widespread, very common kinds of problems that can mess you up if you're not able to handle them well. The state bar did a similar kind of survey in California, and you see very similar patterns. So people have lots of issues around health, access to healthcare, use of insurance. People have issues around money. People have issues around their livelihood. People have issues around their housing. And of course, people have family issues. So very common problems that fall in core areas of life. And just to give some concrete examples here, if you think about the ones that have already become court cases, so this is all pre-COVID, because COVID will have changed this landscape considerably. But before COVID, there were 3.5 million evictions being filed every year in this country. And the tenants involved in them have a civil justice problem, as do the landlords. You had 4 million workers having their wages garnished for debt. So that's already been achieved as a legal action. You have 1.5 million people involved in adult guardianship actions. Then there's a whole set, a much broader set of situations that could land you in court or could make you the object of, or the actor in legal action, but may not have done so yet. So that's people behind on different kinds of payments, like their student loan payments. That was 7 million people or so before COVID. There are people around the country raising children who they are related to, but who are not their biological children. So grandparents do this all around the country for a whole range of reasons, because of deployment, because of disability, because parents are dead. This sounds like a really nice, straightforward thing, but actually it stops being straightforward once you want to enroll your grandchild in school or get them vaccinated or attach them to health insurance. That creates all the need for all kinds of legal instruments. We have almost 16 million people caring for an adult with dementia. And we would want to make sure that however that was working, it was governed by things that were respectful of both parties that were involved in that really important act that's going on. And you have at least 8 million people living in housing that the government says is moderately or severely below code, essentially. It's violating, it doesn't have hot water, it doesn't have windows, that kind of thing. So lots and lots of these concrete experiences around the country. And of course, then the economic shocks that we faced have created many, many, many more filings for unemployment insurance, which then will cascade into many, many, many financial problems and other kinds of problems created by the lack of income or the need to secure income or to fight with the unemployment agency about your income and so on. These problems are challenging on their own, but they're consequential also in sort of knock-on ways, to use an expression Crispin might use. So with a colleague and I estimated that before COVID, 19.5 million justice problems were causing people to have impaired health. So they reported worse or damaged mental or physical health. 18 million justice problems were leading people to lose income, to lose their jobs, or to lose their housing. 13.5 million justice problems were leading to damaged relationships, and almost 5 million were leading people to self-report that they were now having difficulties with different kinds of substances. If you look at how common these problems are and how they occur at different points in your life, what you can see is that people actually spend large portions of their lives dealing with these problems. And if we don't change anything about what we do now, if you're in midlife and you live in America, you can expect to spend about 2/5 of the rest of your life dealing with one or more civil justice problems. And because those problems create consequences that can also be challenging to deal with, If you're in early adulthood, you can expect to spend about 1/5 of your life dealing with one of those hardships, dealing with the fact that you lost your job because of a justice problem, or you have a health problem because of a justice problem, and so on. So very common, very widespread, highly impactful events. The other thing that we know from a whole range of studies is that most civil justice problems experienced by anyone in America never get any kind of legal service. They never go to a lawyer, they never become a court case. So if you're thinking about civil justice activity as a pie, the slice that's getting help right now is very small. So in the United States, a conservative estimate, it's a very conservative estimate, would be 150 million new civil justice problems every year, of which a small portion gets some kind of legally expert assistance. In California, the conservative estimate would be something around 9.3 million new civil justice problems a year, most of which also get no kind of legally expert assistance. So a lot of activity and not a lot of help. So if you're thinking about civil justice from the perspective of the public and not from the perspective of the court system or lawyers, the court system and lawyers are sitting at the top of an enormous iceberg. It's all those millions and millions and millions of problems, of which a tiny sliver is making it up to be noticed, to be assisted, to become matters of record, to create precedent, and so on. When I started doing this research about 15 years ago, I thought, as most of us did at that time, I think that the reason people don't get help with their justice problems is because lawyers are very expensive. And that turns out to be true sometimes and not other times. Sometimes lawyers are very expensive and sometimes they're not. And a great example would be a simple will. A simple will is a few $100s, yet most Americans, even Americans with complex estates, don't have wills. So it's not just cost that's a barrier here. One of the most important barriers is that people don't understand that the problems that they experience in their lives are legal issues. And so one way to see this is to talk to those people who've done that survey and they've told you that their landlord won't fix the heat, or they've told you that their employer won't pay them overtime, or they've told you that they're 3 months behind on the rent, whatever the concrete situation is. And you can ask them, what kind of situation is this? Is this a legal problem? Is it a personal problem? Is it a moral problem? Is it a bureaucratic problem? And the thing that's incredibly striking about Americans is that the most common way they will describe civil justice problems is as things that just happen. So either bad luck, this is just sort of what happens to all of us and it's happened to me, or part of God's plan. So this is happening because of forces that are bigger than me, but it's allotted to me. There's another chunk of problems that people describe in a way that suggests they don't think they're appropriate for third parties to meddle in. So these are our problems. They're my family's problems, my community problems. That's about 1/5 of justice problems people describe in that way. And it's only a minority of these issues, all of which are justiciable, all of which invoke law. It's only a minority of these problems that ordinary people recognize as actually having legal aspects. And so if we're thinking about connecting them with help and connecting that activity with the rules that are meant to govern it, this is one of the biggest barriers that we have to think about overcoming. Why were the kinds of services that Crispin Passmore was talking about being made possible in the UK and that various jurisdictions in the US are exploring, why would those make a difference if it's not just about money, it's also about understanding and the way people frame their problems? Well, this is where I can economize. One reason is that the world is changing. So as Crispin explained to us, there are new kinds of legal services providers being permitted out there in the world, and there are new kinds of ways of producing and profiting from those services that are being permitted out there in the world. Why is this happening? Well, as Crispin explained, this has been possible in other places for a short time, if you're talking about ABS, or a very long time, as Crispin explained, if you're talking about what we would call the unauthorized practice of law. Even if you look in the United States, ABS has been permitted in a certain kind of way in the District of Columbia. And even if you look in the United States, and certainly if you look at the United Kingdom and other places, non-lawyers have already been providing authorized legal services in a whole range of ways for many, many years. One way to see this is to think about how these models, as experienced by the public, differ from the traditional model of a lawyer. So you can think about capacities, and then you can think about kind of distributing them to different kinds of providers. So what can a lawyer do? Well, a lawyer can be you, in a sense. A lawyer can represent you. A lawyer can do things on your behalf. A lawyer can give you legal advice. your communications with that lawyer can be protected from disclosure to third parties. A lawyer can give you legal information, which anyone in the US can do. And the other thing that's really interesting about American legal certification is once you get your degree and pass the bar and we stamp you as licensed, you are omnicompetent. You can get up the day after your bar passage and defend someone in a capital murder case, or help them, launch a company, or help them get divorced. You are formally qualified to do anything within the practice of law. So that's what lawyers do. And if you look at the models that exist in the US and around the world, they take pieces of that and they distribute it to other kinds of providers, some of whom are people and some of whom are algorithms, computer programs, software. One of the things that you see about those models that distribute out, they almost never try to be omnicompetent. They almost never pretend that they can do every area of law. They say that they do some of them. As you see a range of these different kinds of activities, even in the United States. So this is a picture of a woman holding up a picture of a rat, and she's using a software program called Just Fix that comes out of New York City. And what this does is it doesn't tell you about the warranty of habitability or New York State housing code. It says, are there some problems in your apartment that you would like your landlord to just fix? Okay, here's a guided interview. Do you have hot water? Are there leaks in the common areas? Do the elevators work? Do you have these different kinds of pests? And then after you fill out that interview, it says, okay, you just told me you have dead rats in your basement. You have this leak in the bathroom. Go take a picture of that leak. You go through all of that. It writes, you press submit. It writes a beautiful letter to your landlord that cites New York City housing law, that points out that it's provided date stamped, time stamped, geolocated photos that show that those violations are in the apartment that that landlord is responsible for. And then it sends that as a certified letter to your landlord. The goal is to get the landlord to make the repair, but then you also laid the legal groundwork, if necessary, to start a housing court action against your landlord, right? All by just using a little computer program. That's a pretty sophisticated example that's nudging up on legal advice. But basically it's helping you write a letter. There are things that go further towards what traditional lawyers do. So a range of states around the country have licensed paralegal programs of different kinds, licensed document preparers of different kinds, where those folks can give you legal advice. They can take actions on your behalf. If they're fully licensed and certified, you often have privilege with them and so on. They never claim to be able to do everything. They usually claim to be able to do 1 to 5 things. All around the country, you have sources of legal information that may also include the ability to fill out a form. So a smart form filling thing that would let you file for divorce or respond to a debt claim. Those exist around the country, and they're currently permitted under the existing rules because they're considered to be legal information. You also have more sophisticated forms of legal information that go into the courts themselves. So this is a New York City court navigator who's assisting a woman who's being sued for eviction in Brooklyn. And what he can do for her is help her get her argument together. He can't advise her on what it is, but he can help her put together the pieces of evidence that she's likely to want to show to the judge. He can help her figure out the order in which different things are going to happen and what courtroom to go to. And he is permitted under the court rules to answer factual questions addressed to him by judicial staff. So he can't make a legal argument, but if the judge or the court attorney says, does Mrs. Robinson have a receipt for the rent? He can say yes, and here it is. So there are a whole range of ways to design these roles that allow people to receive assistance from someone or something other than a lawyer, but have the capacity that empower those roles to do things that can be very valuable for people facing justice problems. It turns out consumers really want something that's not necessarily a lawyer a lot of the time. So if you look at the evidence that we have, people are usually not looking for full representation. What they really want is someone to explain to them what is happening and what the choices are. Even in situations where what you want is representation, people are actually very happy to use non-lawyers when those providers are available. And I think one of the most interesting things that comes from this research is if you provide people a wider menu of choices for responding to that body of problems, they're more likely to do something than if you provide them a menu that has only one item. So one way to see that people are looking for legal advice is to see what they type when they write questions to legal aid agencies. So I had some students analyze some live chats in a couple of states where people are typing in, you know, I just got this paper, what does it mean? Can my husband be jailed for not paying child support? This kind of thing. And if you look at those questions that are being asked online, and you say, okay, is somebody looking for an attorney? Is somebody looking for advice about their situation? Is somebody looking for a referral? What you see is that people sometimes want attorneys, but the most common thing that they want is for someone to explain to them what this is and what their choices are. Another way to find out what people are looking for is to talk to people who've actually gone for help. So in those justiciable problem surveys, if someone says, yes, I went to someone for help, you could say, okay, when you went to the lawyer, or when you went to the social worker, or when you went to your city alderman, what is it that you wanted? Did you want this person to solve the problem for you? Did you want this person to help you figure out what your options were? Did you want this person to tell you where you could go for help? And what you see is that whether you're looking at people's attempts to get help from their friends and family and neighbors and so on, or whether you're looking for their attempts to get help from formal sources, so that could be a lawyer, but it could also be a community organization or a government agency, the most common thing people want is legal advice. They want someone to explain to them what this is, what it means, and what their choices are. When non-lawyers are available, people are really quite happy to use them. In the US, for over 60 years, people who are not lawyers have already been representing clients in a range of contexts. And I learned from the introductions today that one of those such people is on this task force, which is fantastic. So if you look across different studies, you'll see that typically when non-lawyers are permitted to represent folks, they're 1/5 to 2/5 of the representatives of people who have representatives. So they show up in unemployment compensation appeals, they show up in state tax courts, they're permitted in lots of federal tribunals around benefits, and they show up there. And then of course, if you're accredited, you can appear, if you're part of an accredited organization, in federal immigration matters. So when these things exist, people are quite happy to use them. Now, the most interesting thing I think about this research is that once you provide that bigger menu, as I said, people are more likely to do something rather than nothing. And one way to see this is to compare two jurisdictions that differ in some important ways. So you could think about a jurisdiction that has a little bit of legal aid, so it provides some, as a matter of entitlement, some amount of lawyer assistance, but it doesn't provide much of anything else. So it doesn't have the advice sector that Crispin was talking about. It doesn't have the ombudsman that Crispin was talking about. It's sort of lawyers or nothing, and there's not a lot of law. And you can compare that to a context where you have all of those non-lawyer providers, but you also have a much more generous legal aid system. Many more people are entitled to take public funds and give them to private attorneys to provide their legal services. Sometimes that's called a judicare system. So if you look at how people handle their problems in that place where you've got lawyers or nothing and very little legal aid, which should seem familiar to you because it's where you live, what you see is that if you're looking at people who are experiencing money and housing problems, the most common thing people do is try to solve the problem themselves. About a quarter of them try to go to law. About a quarter of them do nothing at all, and less than 10% go to a non-legal third party. Because why would you? They can't do anything for you anyways. They're prohibited from doing it by UPL. If you compare that to the UK before the 2007 reforms, what you see is that the most common way that people handle civil justice problems involving money and housing is still to try to handle it on their own. But almost nobody does nothing. So we go down from a quarter of these problems being handled by complete inaction to only 5%. We see that many more people are going to non-lawyer third parties, to the ombudsman, to the nonprofit advice sector, to the community advice bureau to get assistance with these problems. And we see that only 10% of these problems are going to lawyers, even when law is free, right? Because this is the context that has an expansive and generous judicare system. So if you provide people more alternatives, they're more likely to do something, and they may not choose fully qualified attorneys, even when those attorneys are free. All right, well, we wouldn't want to give people a service if it wasn't a good service. And so Crispin mentioned this, research pretty consistently demonstrates that when non-lawyer professionals are specialized, they'll do as well or better than traditional attorneys. And I'm going to illustrate that with just one study. So this is the study that he referred to by Richard Moorhead and a bunch of colleagues that compared across personal client fields, solicitors, so formally qualified, reserved occupations, and non-lawyer providers of different types. And the way they did the study was to audit the work product for a random sample of each of these different kinds of providers. And the auditor was an expert in that particular area of law who was independent from the provider. So a classic kind of audit study. And the question was, is this work, as Crispin put it, is it good enough, right? So is it competent? And then is it excellent? And the first thing you see is that about a quarter of the time, both solicitors and people who are not solicitors make mistakes that are significant enough that the work fails. At the same time, that also means that in both cases, 75% of the time, solicitors and non-lawyers do quality work, work that is adequate, work that has a passing grade. And Crispin mentioned this as well. The non-lawyer providers, because they're specialized, they don't try to do everything, they try to do a few things. We're about 8 times more likely to do work that these independent reviewers rated as excellent than the solicitors were. So we have, this is just one study, but we have lots of good evidence that non-lawyer providers can provide really good, effective, safe services to people. So we have a lot of opportunities here. And this is, I've presented you with a big problem, and I presented you with some opportunities to think about how we might solve it. One of the opportunities is greater consumer choice. Another opportunity is designing services around clients rather than around ancient professions. The thing that we're really after here is expanded access to justice, expanded and equalized access to justice. But that may have collateral benefits for not just attorneys, but other parts of the economy and the source of new sources of revenue and investment. And we might get some more efficient regulation here if we think about some different ways to do this. So that's all I have to say right now, and I'm happy to take your questions, and I'm very much looking forward to working together with you.
So far, no raised hands. Must be one question out there. Let's see. Okay, let's see. Ah, Randy. Randy, go ahead.
Becky, I was just wondering, Crispin referred to culture as being an issue, that even if there is regulatory change to promote new delivery systems, new legal services, products, et cetera, that culture might still be an obstacle when you're really trying to counter years and years of mindsets about how to solve problems. Do you have any insight from the data in terms of if regulatory reform is achieved, what cultural impact it would have, and if it wouldn't, what other steps besides regulatory change might be taken?
That's a great question. So Crispin was talking about the culture of legal professions. And I'm going to flip it and talk about the culture of ordinary Americans and why they handle their problems as they do. And so Crispin made one point that I think is worth repeating, which is that it sounds bizarre, but supply can create demand. And the example I usually give for this, because it's silly, is bananas. So bananas used to be enormously expensive, and only rich people had them, which is why they were on those beautiful bowls in those old movies from the 30s. But everybody ate fruit. They just didn't eat bananas because bananas were crazy expensive for rich people. And then bananas became much cheaper because of all kinds of economic changes and trade changes. And now we all eat bananas. And we all think bananas are nifty, and we have banana bread and blah, 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 blah. So the demand for bananas increased because more bananas were around. Crispin's example was, if I have a $5 problem, I might pay $1 for legal services, but I'm not going to pay $5,000 for legal services. So there's that effect. But if you look at the places where these kinds of services are effective, they don't usually go under banners that say free legal services here. They go under banners that say, you're in a low-wage job. Let's talk about getting a fair pay for the work that you do. Or, wow, your apartment is really crappy. You don't have any heat and there are rats running around. Let's talk about how you might get that fixed. And so if you have providers that are focused around the problems and experiences that people have and they want assistance with, That's a cultural change as well. It's a cultural change for the providers because they're not advertising just law, but it's a cultural change for people who can come to recognize that these are problems they can act on. It's not just bad luck, right? It's something that we could do something about.
I have a question, and I don't know if I don't know if I'm supposed to raise my hand, you know, whatever, I'm just going to put it out there. In the research you were just talking about a few slides ago, which was really interesting, with the graph showing the excellent proportion going higher for the non-lawyers. What types of work were those non-lawyers doing?
So they were helping people with benefits claims, with immigration claims, with employment issues, with debt claims. I think there was another civil category. I'm not sure what was in it. They were not helping people though with complex civil litigation, right? They were helping people with kind of routine justice problems that all of us experience at different times.
Did that include some level of representation before an administrative, you know, officer or something like some of these might? Do you know?
It can, yeah.
Okay.
There are many tribunals in the UK where non-lawyers can appear.
Hmm.
Jim Sandman?
Yes. Becky, thanks as always for a wonderful presentation. One of my takeaways is that the system that we've created is not responsive to what people say they want and need. And that isn't really surprising to me because the system we have is a creation of lawyers. And just as to a hammer, everything looks like a nail, to a lawyer, every so-called legal problem needs a legal solution with a lawyer. So I guess I have two questions about how we deal with this. One, do you know how in England and Wales, when they came up with the system that they have and that you contrasted our system to, they had greater opportunities for public input than we have in ours. We nominally, in the formulation of our regulatory system, have an opportunity for public participation, but as a practical matter, it's next to nothing. Most real people don't spend their time lurking around bar and court websites looking for opportunities to comment on proposed regulatory changes. So do you know whether systems that you think are more responsive to real consumer wants and needs have a more meaningful opportunity for public input? And second, even if you don't, how do you recommend this group go about its work to try to get the kind of input that you're reflecting in the research you just presented?
Thanks, Jim. Those are great questions. I think one of the things that's really interesting about the UK system is that it had very generous legal aid, which meant a lot of money was being spent by central government on providing these services. And we, of course, as you know, don't spend very much money centrally on providing services. But if you're spending billions of pounds, you want to think about where that money is going and where it can be most effectively and efficiently routed. And so in addition to having this very generous legal aid system, beginning in the 80s, the UK had an agency of government whose job it was to understand people's legal needs and think about, did they need solicitors or could they go to a citizens advice bureau? How could we design services around the problems that people have? And so making that kind of investment in understanding public experience, I think, can be very valuable. This group doesn't have that budget. I think there is the possibility of some kind of survey activity contemplated, but you want to think about that as one route. I think there are two sort of low budget ways to get public input into this. So one is to go to community providers of help that are not lawyers and ask them what kinds of situations people are running into, what kinds of clusters of challenges they bring. I think that's a very important perspective. I think a second is to talk to people themselves, ordinary people who have whatever going on with them that they have, and not ask them about their legal problems, but ask them about the situations that they confront. I'll give you an example. Years ago, I did some focus groups, and all I did was go into the library and say, I'll give you some money and some cookies if you talk to me for 2 hours. And I said, I'd just like to hear about kind of what's going on at work, what's going on in your neighborhood, what's going on with your family. Let's go around the table and tell a story. And one of the striking things is there was one story out of 120 people that didn't implicate a civil justice problem, right? I mean, there's just, these things are so common. And it was in allowing people to describe their own experiences where I began to recognize that the recognition of the legal aspect of this stuff is actually really, really rare for ordinary people. And so the entry points need to be where they already are. So if they're going to help at church, we should be at church. If they're going to help at a community organization, we need to connect them to help there. And you, when you were head of the Legal Services Corporation, were genius in promoting some of those ways of connecting people to legal aid lawyers and embedding legal aid lawyers in health clinics, in faith justice partnerships. Another thing to think about is instead of embedding lawyers, or in addition to embedding lawyers, can we embed other ways of giving legal expertise? And I think that's a really big opportunity here.
Thank you.
No more raised hands at the moment.
The after lunch crowd is always a rough one.
Your presentation was awesome, and we have the advantage that you'll be with us for the duration. So if there are no more questions now, I think we should move right to the next presentation.
John Lund?
Reem does have her hand raised. Yeah. Sorry.
Oh, let's do that before we go.
Thank you. Just a general question around, your presentation focuses that the majority of people want to seek out, advice. That's the most urgent need, is advice, and maybe telehelp or limited scope representation is one way to provide for that. And I know that currently there is legal help subscription services. So I think Rocket Lawyer has such a service. There's also the MetLife legal plan. Has your research shown that those are effective means or ineffective means as opportunities for people to seek help?
So something is always better than nothing. And so if those services didn't exist, even fewer people would be getting assistance. But one thing that we know is attempts to provide things like legal insurance in the United States have been almost unqualified failures. Because if I don't see my daily life as having legal aspects, why would I buy insurance for something that is never going to happen to me? And so sort of thinking about ways to meet people where they are as they think about their own situations, I think is the entry route there. Rocket Lawyer, for example, is very interesting. If you look at what it actually does, so one of the things these surveys do is they say, okay, is divorce a legal problem? Is wage theft a legal problem? Is hating your mom a legal problem, right? All these different things. And so people understand that divorce and wills and contracts are legal because they're legal documents. And that's what Rocket Lawyer helps with. People don't necessarily understand that if their employer keeps making them work third shift, but never makes the guys work third shift, that's also a legal problem. And so Rocket Lawyer can't, at this point, connect with that chunk of the need. So it certainly, those kinds of services serve some things, but there's a huge set of really important problems that they don't reach right now.
There's one question that I'll read from the guest attendees, Stephanie Bond. She says that she's curious to know how 150 million people in the US have a legal problem. Isn't that basically 1 in 3 people?
Well, it's probably more than that. And it's 150 million problems, not necessarily 150 million people. So if I lose my job and I apply for unemployment and then I can't pay my rent and then I also am the object of a debt claim, I'm at 3 there probably. So that's part of what's happening. But the reason you see these enormously high numbers of justice problems is think about all the stuff of your life that's governed by the civil law. So anything that involves any kind of contract, whether you know there's a contract there or not, is a civil legal issue. All kinds of relationships, family relationships, relationships with employers, relationships with neighbors have aspects that we have decided that we want to regulate with civil law. So there's so much of ordinary life bumps up against that it's actually really easy to have civil justice problems. And I just want to give one example that I got from a law professor when I was giving one of these presentations years ago. She said, you used to talk about how no one sees that their problems are legal, and I thought you were crazy. Of course, everyone knows that they have justice problems. She said, and then my mother went into a nursing home and I was trying to deal with her finances and I didn't know what to do. And the social worker came in and she said, you know what you really need is a lawyer to help you set up these arrangements. And she said that was a really illuminating moment for her because of course she was a lawyer, right? That she herself couldn't see that that was a justice problem that could benefit from legal expertise. And so I think that's a key thought shift, I think, to make here.
Okay. I can't see the hand raised feature, but if anybody wants to still jump in with a question, now is last call before we move on.
This is David Engstrom. Can I ask a question?
Absolutely.
Sure. So Becky, I'm curious of these civil justice problems or unmet justice needs. Like what percentage of them would you say present what we could call a litigable problem? So, you know, a big chunk of these, for instance, are evictions and consumer debt issues. And there's simply an inability to pay. Like like clearly, if it went to court, it would produce a judgment in favor of the creditor, one might argue, because the simply payment hasn't been made. And those are cut and dry cases. Now, there are lots of explanations for that: widening gap between rich and poor, deepening poverty. Like there are all sorts of reasons why there's been a run of these sorts of cases, especially in our state and local courts. But they aren't litigable. What people might need is some understanding that there's a payment assistance program that the state runs. You know, California, I know Michigan has some things like that. So the need is informational for sure, but it's not necessarily legal information in the sense that there is nothing that could be said in a court proceeding that could avoid a judgment. And so that's, you know, one explanation then for why we just get default judgments in so many of those cases is because there isn't a litigable issue. Am I thinking about that totally wrong? Or maybe alternatively, to frame the question in an empirical way, like what percentage of these unmet justice needs do you think fit that pattern?
I think that's a really good question. I think we've set up a system where the only entity that can make that decision is a court, right? And it would be very difficult to design a survey that would elicit all the information that would let you answer that. But I think you're absolutely right that there are people who could benefit from other kinds of information who are involved in these challenging situations. They could also avoid getting into some of these challenging situations if they understood the legal implications of decisions they might be about to make. They could also, one of the terrible things that happens is people die and then creditors go after their descendants for debts that they actually have no legal obligation to pay, right? So what do those people need? They need someone to explain to them they have no legal obligation to pay. There's a range of information you need when you run into a problem. I think you're absolutely right. We can't say at this point, if we invested $300 million in providing these services, it would serve the 45% of action of sort of cases courts would take if you brought them and took them to the point of having them assessed. We don't have that kind of precise information, which I think is a great point. Because underneath the very elegant way you asked that is, how big is unmet legal need? Is it 150 million people, only a quarter of whom are getting some kind of assistance? Or is it half of that or a third of that? And we don't at this point have a good handle on that one.
So Becky, if I might add, this is Donna Hershkowitz. So California published our justice gap study at the beginning of 2020. And what we concluded, looking at the same justiciable issues that Becky had mentioned, right? We didn't ask about, do you have a legal problem? The survey asked about substantive problems which had previously been determined by the surveyors as justiciable issues. And based on that, it was determined that 85% of the legal problems that people experienced, they received inadequate or no legal help for. And one of the things, you used a perfect example, David, with the evictions that I want to sort of be clear on. One of the things that we sort of constantly talk about when we're talking with legal services folks is, you may not win, right? If you bring, if you defend, a tenant in an unlawful detainer case, they may absolutely get evicted because that's what the circumstances would dictate in that case. However, what we've found is that having a lawyer present has resulted often in extra time for the tenant to vacate, right? To get their things in order to find another apartment to rent. And so it has a real impact if they don't have access to justice because they may be evicted immediately and not have those extra days in that kind of circumstance.
All right. Thank you, everybody. Let's take a 60-second break while we let John Lund get his screen sharing up and running, because I know he has slides. And then we will be off to the races with our next wonderful presentation. Oh, he doesn't even need 60 seconds. Impressive.
Do you want me to, where am I though?
I see.
You're in presentation mode, I think.
Yeah, maybe I need 60 seconds.
All right.
Just click on, go to slideshow and click from beginning on the top left corner.
Yeah, I will. I was worried my mic wasn't on.
Oh, no, you're good.
Okay.
Whenever you guys are ready.
So is it up?
Yes, it is.
Okay, great. Well, then I'll just jump in if that's all right, Justice Tucker.
It's absolutely all right. It looks like you might be able to expand it to whole screen, which might help when we get to smaller print.
Yeah.
On the top left corner, it says from beginning. It's a little screen that has a green triangle on it.
Oh, that's where I am. Okay, so I'm in the wrong spot. How about that? Is that better?
So click on that and then give it a second to load. Hold on one second. Let me see if I can help you with this.
Yeah, you know what I'm going to do is
Here, I'm going to ask you for remote control. Hold on one second.
Okay. Sorry, folks.
It's all right. World for all of us.
Give me okay, I have control now. Hold on. Although you're not on that. Oh, it's not clicking anything.
Okay,
There's a PDF version of this, Mimi, in the.
Yeah, I just approved, Mimi. You can turn me on now.
Okay. Although it's not really, oh, there we go, hold on. Now, from beginning. Let's do this.
No.
Oh, so you said resume, hold on.
This is the problem I was having earlier.
Oh, it's not working. Okay, how about this? 1 second, John. What I'm gonna do is this. I'm gonna share my screen instead.
Okay.
And what I can do is I can bring up your presentation and you can control it. So just give me a second.
Great. Thank you.
No problem.
You have a nicer screen than me anyway.
Okay, and then what I'll do is I'll give you control, so then you can control it with your mouse, just click.
Okay. But so far I'm just seeing your
There you go.
So far I'm just seeing your backdrop.
Oh, okay, I put it on the wrong screen. 1 second. Hold on. You share this one. Sorry, I have like 3 screens. Can you see it now?
There we go.
Yes.
How's that?
Okay, and I move the mouse and make sure you can control it.
Yeah, I can. Thank you.
Okay.
So there's an object lesson in how little lawyers know about some things that they think they know about, which is how to run PowerPoints. And I think it's no accident that our first 2 presenters of substance here were both non-lawyers who are studying, our profession and legal services kind of from a completely different perspective. And I think that's really an important piece. As far as Utah, one thing for context to have you all understand is, we have 3 million people and we have 10,000 lawyers. So in the concept of laboratories and the states operating as laboratories, we're kind of a nice sized laboratory relative to to California. And I think that's part of the condition that allowed us to sort of move forward as we have. And we certainly have a lot to learn, but I'm anxious for this chance to compare notes, because I think it's sort of obvious that the market forces and the innovation we're really hoping to bring to bear only make sense, when they're taken to scale. And that somebody might try something in Utah is great, but the innovators are really going to be attracted if there's an opportunity to take that to scale. Our journey in Utah basically has about 3 parts to it. We spent about a year researching and wrote a submission to the Utah Supreme Court that was submitted in August of 2019 that made a set of recommendations around reimagining the regulation of legal services. The court adopted those recommendations that we made. That's a 50, 60 page submission that we gave to them. And then they set up a second task force to get involved in implementing those recommendations. And that group, which I guess I co-chaired both of those, but Justice Amonis and I co-chaired that second group, and Becky Sandiford joined us at that point. That was about writing up what the rules ought to be for a sandbox, how the structure ought to work. And then also importantly, we worked with the Rules Committee of the Utah Supreme Court on the rule revisions that needed to be part of that as well. All of that went out for public comment in the midst of the pandemic. And ultimately in August of last year, in August of 2020, the court approved the rules changes and indeed established the Office of Legal Services Innovation, as well as the sandbox in Utah. So that's where we are. And what I thought I'd do, let's see, is that controlling? Is that moving, Mimi, or do I need to ask you to maybe move for me?
Perhaps, because it's not moving.
No, it's moving. You just need to click and it should go to the next slide.
I did click and it didn't, so.
Okay, 1 second.
Okay, thanks, that's it. So I'm going to cover these 4 areas. 1, a little bit about what the structure is that we've established in Utah. 2, sort of the principles that we've established that we think should inform the regulatory process. Just the procedure that we have for people that are sandboxers that are coming in that want to propose an innovation, and then a little bit about the progress that we've had so far. Okay, Mimi, I'm going to ask you to advance that. So in terms of structure, the primary rule change is around 5.4, which I just want to remind everybody, that's about the professional independence of lawyers. That's what that rule is about. But imbued in that rule, as we all know, are these various economic constraints on what lawyers can and cannot do as a matter of economics, which are largely driven by a presumption, that if you shared fees with a non-lawyer, that would undermine your professional independence. So when we rewrote that rule, it now permits such things as non-lawyer ownership, sharing fees with non-lawyers, and lawyers also practicing with non-lawyers in multidisciplinary sorts of arrangements. Now in Utah, the way the rule works, you can only do those sorts of things if, first and foremost, there's no interference with professional independence, with the duties of loyalty that are owed to a client, or with the protection of client confidences. And as was asked, I think of Crispin earlier, none of these innovators are somehow or another excused from the fundamental ethic responsibilities that lawyers have. And then the last piece for our structure is, if you want to, and this is a little different from Arizona, with which some of you may be familiar, but if you want to do any of these things in Utah, you must comply with that, and you must go into the sandbox. In other words, there is not an opportunity to explore these innovative ways of practicing law or providing legal services unless you go through the sandbox, which is specifically really to comply with what you see there references Utah Supreme Court Standing Order number 15. Okay, Mimi, let's look at the next one, please. And Standing Order number 15, and by the way, I've included in the agenda here the Standing Order, the rule, revised rule, our Innovation Office Manual, which has a bit more substance than the order, and then our most recent report to the court, just to give you all a feel for the kind of documentation that we're relying on with our sandbox. But importantly, the standing order makes it clear that the overarching goal of this reform is to improve access to justice. And therefore, we have a singular regulatory objective, and that is to ensure consumers have access to well-developed, high-quality, innovative, affordable, and competitive market for legal services. That's a mouthful, but I do think it touches on something that Becky was just referring to and that was being asked of her. This is about access as much as it about the quality of the service. This is about letting market forces and innovation help people understand, well, how to identify that legal problem, help people understand what they might get in the way of money, of service to assist them. You know, this is a trite example, but I never really understood I needed lattes every day until Starbucks communicated that to me. And that's just an example of how the economics of an open market can help people understand what they do and don't need. Now, you know, that's a trite example, but I think those same forces potentially pertain here. Standing order number 15 establishes this regulatory sandbox. It is a pilot. It is an experiment, and it's an experiment about experimentation is essentially what it is. It does also establish this office that I now chair. We have 11 people that make up our board. We have an executive team. We have some funding in order to actually try to operate as a regulator. And then the last key here is that our requirement from the court is that we used a risk-based approach to the idea that we might recommend somebody for approval in the sandbox and assess based on data. I just want to stop for a minute and point out, this is the Utah Supreme Court exercising its regulatory role and its regulatory responsibility here. Its responsibility is to try to assure that there's a market of legal services, which of course is a little different, quite a lot different than assuring a particular set of providers, i.e. lawyers, continue to have, you know, the corner on the market. So that is the structure that we have put in place. By the way, it's a 2-year sandbox. It could be renewed, but it has a sunset provision. So within 2 years from when we started, which was August of 2020, we would need the court to decide if they want to have the sandbox experiment continue. Okay, Mimi, ready for the next one, please. Oh, you skipped one there. In terms of principles, this quote here is from the order itself. So these are the Supreme Court's directions to us. Regulation is evaluated based on risk to the consumer. It is compared to the current legal services options available. So when someone comes in with a potential service, you don't compare that to what a lawyer would do at an hourly rate for that person if that person had an unlimited budget, because that's just simply not their other option. We're looking at trying to predict potential harm and what amount of harm is acceptable in a certain setting. You know, I think it's evident that the types of things that we'll see first in the sandbox are going to be discrete services around known problems. No one's going to be suggesting a sandbox innovation, you know, for handling felony criminal cases in all likelihood, because there's just much more potential harm. We're to be empirically driven and market-based. Okay, Mimi, please move on. Thanks. So then I want to highlight to the left here with largely the efforts of Becky and Tom Clark and our executive director, Lucy Rica, we've written about a 15-20 page manual about the process that we're trying to utilize. And that's also in the materials. But the heart of it is what you see here on the screen. We've identified just 3 simple potential risks to consumers that we want to try to suss out when someone applies to be in the sandbox. Are they going to get an inappropriate, inaccurate result from this model? Are they going to somehow fail to exercise a legal right, either because they're ignorant or because of bad advice through whatever this model is that somebody is proposing? Or are they going to be oversold? I think that's a realistic concern here for the consumers, that we don't want somebody buying things they don't really need in the way of legal service. So that manual has a lot more substance in it, but that's really the central criteria. To begin to assess applicants, Mimi, if you could advance forward, thank you. There's really sort of two moving parts to how we categorize applicants. The first is there's been some consistency in terms of service models. So you'll see those listed there. A lawyer who is employed or managed by a non-lawyer. That's the easy example of that is Rocket Lawyer in our jurisdiction sought leave to directly employ a lawyer as opposed to having that lawyer be one that they referred out to, who then provides legal services to third parties. That's a model. There's a model of less than 50% ownership of the entity that's being regulated. Another model would be 50% or more lawyer ownership. What we've done here with this categorization is kind of use the logic that the further something gets away from the traditional provision of legal services by a lawyer, the more potential risk there is. And so you'll see that this table runs from low risk, where it's still just the lawyer providing the services, to a higher risk at the very high level. These are non-lawyers with no lawyer involvement providing the legal service, or an algorithm with no lawyer involvement, no lawyer review providing the service. Those are the higher risk sort of service models that we see. And each applicant that comes in, we kind of try to categorize which of these models are they, or one or more, are they trying to utilize in what they're proposing to us. Okay, Mimi, please send it forward. And then the other main key is to the applicant, what service categories, what type of services do you want to provide? So they apply for a particular model to use and then a particular categories of service to use it. There's a fellow in here who's just doing bankruptcy law. He's not pretending to do any other kind of law. He doesn't want to do any other kind of law. So he's only authorized right now to do financial services. And if he wanted to come back and expand his business to other models, he would need to come back and seek authorization to do something more than that. And then if we can go to the next piece, slide 9, please. You know, the heart of any experiment is getting good data and then testing your hypothesis. I guess our hypothesis is that we believe innovation and market forces can improve access to justice by making legal services more affordable and more accessible. To get that information, any participant in our sandbox needs to comply with certain data requirements. What I have up on the screen is the data requirements for a non-lawyer provider who has some lawyer involvement. So this might be we have an example of a victim's advocate, a social worker who is seeking to give advice to domestic abuse victims. That's a non-lawyer who wants to go the next step, not just helping them through the system, but giving them advice about the content of what's happening. If there's lawyer involvement in that at some level, and it's probably not, I don't think I should take the time to explain how we kind of looked at lawyer involvement, but with that model, then that provider needs to report to us. They report monthly on the things you see at the top there. The number of people served. Where are those people? Where did they live? What revenue is being generated? Are there any complaints? Every month. And, you know, contrast that to what we learn about a lawyer that just got admitted to the bar and what they do with their license. I mean, we're really trying to be sure we've got a good flow of information back from anybody who's been authorized to operate. The other piece of this for somebody with a moderate risk data requirement is that we're asking for a series of details about the specific consumer service. So what was the outcome? What was the non-financial outcome? What was the financial outcome? And in some instances, we're using the idea of expert review of those provisions. So the victim's advocate gives advice to 10 domestic abuse victims. We would ask that a lawyer who's proficient in advising domestic abuse victims review those 10 instances of service being provided by a non-lawyer and give us information about that. And in this instance, it's 20 of those interactions. So that's a way of kind of trying to make sure we've got a good feedback loop from anyone who's in the sandbox. Okay. In addition to data requirements, if we could move ahead, Mimi, there are disclosure requirements, both in the rule and in the communications that the provider has with their clients. They need to use these fairly simple, plain English explanations. This is not a law firm. This law firm is owned by non-lawyers. That could make a difference to what your rights are. Now, you probably half the people on this call could write a tome about the differences between, the importance of being a lawyer, but we've got to find a way to communicate that in a simple, straightforward way to people. And then the other thing is they're all required to carry the badge you see on the right-hand side here in order to make sure that it's clear where the authorization is coming from for this provider to do what they're doing. And that badge, and through other mechanisms, we've created an ability for a consumer to complain directly to us if they have a problem with a service provided. So that part of that would be there'd be a link on this badge to pull them back to our website in order to be able to register a complaint. Okay, if we could go on to 11, please. The process for sandboxers is pretty straightforward. There's an application they fill out online. This is the beginning of it. There's then an iterative process between our executive committee and that applicant. We try to assess it, understand better. I mean, these don't fit into standard categories. So it's a matter of trying to learn more about what they intend to do and really divine that out before we, as an innovation office, decide whether to recommend it to the court. And then if we recommend it to the court, if you'll move to slide 12, please, Mimi, the ultimate authority to permit the person to provide legal services is an order from the court. And that may seem kind of bespoke. Each one of these applicants at this point is getting their own order, articulating exactly what they've been permitted to do by our Utah Supreme Court. But at some level, that's really no different than what happens with lawyers. At least in our state, the Bar Association tests people and does character and fitness, develops a list, but ultimately it's a motion to the court for leave to admit those people to practice law in our state. So this is really the parallel to that of the court permitting this entity to practice law under these circumstances. And these orders are specific as to what they're permitted to do, what models they're permitted to use. There has been isolated instances of needing to also expressly waive a particular ethical requirement, such as a client trust fund issue. If they've got a better way to deal with client trust funds than what might be in the rule, and they want to propose that, then that's an instance where the court may grant them, that entity, a waiver from that sort of a requirement. Okay, so let's turn to progress thus far, which is slide 13. We've had 34 applications so far since August. We've recommended 20 of those in part or in whole to the court for authorization. We've denied one. There's some pending with the court. And we ultimately have 16 entities which have been authorized now at this point to provide legal services. In most instances, I think in all instances, they've been authorized for a 2-year period. And they'll need to seek renewal of that authority in 2 years based on having complied with the data requirements and whatever else in order to be able to continue to operate. If we could move forward one more, please, Mimi. This is probably too dense to take on, but I'll just, across the top, you see several instances of different providers. Blue Bee, that's a bankruptcy provider. All that guy wanted to do was give a 10% interest ownership in his firm to his paralegal. We deem that to be a low risk model. The blue box means that he's got less than 50% non-lawyer ownership, and there's an X only in consumer financial issues because that's all he's allowed to do under his license. But each of those columns is a different provider, and we're tracking, what the setup is with each one of those providers through a form like this. And then the next page, please, Mimi. I just wanted to give you a flavor for the examples so far that we've seen and that have been authorized. I mentioned the one about limited legal advice from victim advocates in the domestic abuse range. We have lawyer employees providing legal services to outside clients. That's what I think of as the rocket lawyer model. Partial firm ownership by a paralegal. I just mentioned that with the bankruptcy fellow. Non-lawyer investment. There's lawyers who have good ideas. They want a non-lawyer partner to help fund their idea. This one at the bottom of the left-hand column, they've got a sort of a TurboTax style system to get the financial disclosures compiled for a divorce case. Many people handle divorces on their own. One of the more complex pieces of that is filling out the financial information that's required. So this is a flat fee charge to walk somebody through that information and provide them with a financial disclosure. We are seeing some models where the law firm is one of several affiliated professional entities, sort of around a multidisciplinary approach. One example of that is there's a lawyer and her partner who's a financial planner who think they know everything soup to nuts about dental practice. So they've got, a whole model around providing services from, cradle to grave for people that are dentists that are doing their own business. One of the kind of exciting ones is an expungement notification tool, which ties in with the BCI database. We have this clean slate legislation in Utah that if somebody qualifies, they may be able to get an expungement. But this tool it gives them notice of that right, and it takes them through the specifics of their case to tell them whether or not they may be eligible for an expungement. And then the last one here on the examples is one that our Chief Justice was particularly fond of. You know how you get spam calls on your phone and you wish you could do something about them. This is just an app that you swipe right and you're automatically signed up into a mass tort claim against that spam caller, with obviously a record having been made of the fact that they called you and from what number and when, by virtue of the fact that they're using your phone. So I'm sorry if that was a whirlwind, but I think, Mimi, we're to the last slide, right? So that's what I have for you today. I really look forward to learning from all of you as we go forward, because we are really cutting from whole cloth here in a lot of respects.
Thank you very much, John. And people should feel free to just unmute themselves and call their questions out. I don't have access to the hand raised feature, but Lauren or someone else who does can also call.
I'll just start with the first question we got from Art Lockman, who's spectating this meeting. Regarding the initial process in the manual for entering the sandbox, on what basis was it determined that there is automatically more risk if a licensed lawyer is not involved? And under footnote 3 in the manual, why does it have to be a Utah licensed lawyer as opposed to a lawyer licensed anywhere in the US? Will this change as data is developed?
Yeah, I think on the first question, Art, and well, hi, Art, it's good to hear from you. Art's been a great contributor to this effort. That's just a starting logic. Until we have some data, the logic is the less traditional the model and the further it moves away from traditional service of practice of law by lawyers, the more potential risks. Now, thanks largely to Becky, we've got several outside groups who are studying and plan to study our data. And maybe our data will tell us that there's actually that's not a good premise, but that's where we started, is with that as a premise. As for why they need to be a Utah lawyer, I guess the short answer to that is we had some lawyer from Florida suggested maybe he could just use the sandbox to start practicing law in Utah. And I guess we're trying to promote innovation, but we're not trying to completely upset the structure. And so, our court's responsibility and authority is to regulate the practice of law in Utah and by Utah lawyers. That's about the extent of that, Art.
Okay, our next question is Donna. Donna has a question for us.
Yes, I actually have two questions for you, John. I think just two. So I wanted to follow up on the comment that you made, saying that the risk to the consumer should be evaluated relative to the available options, and not just to, you know, a full service lawyer whose services aren't actually available because they're not affordable. So I just want to understand, are you looking at it by, you know, having the person who's proposing to enter the sandbox identify that you know, their goal is to, for example, serve somebody at, you know, at X income level, and so then you would subjectively sort of as to consumers at that income level, you would look at the other options that would be available to a consumer out there that could be accessed in the marketplace. Is that how that evaluation works?
That evaluation is probably not quite that fine tuned, and kind of to your point, we do not think it's wise to get in the middle of sort of, well, is your innovation available to people, you know, below the poverty level, or, you know, kind of where, and in part because I think we could all agree that the first people who had iPhones were not, you know, the people working 9 to 5. They were people that had a little more money, but you drive price down, and you get the price point to a place where it's affordable and the demand is available across the board. So that, I think our assessment of that, Donna, is really a more simple, wow, dentists. Let's think about dentists. I mean, they're small business people for the most part. They might engage a lawyer, but they might not. And if this idea that you can have a one-stop shop is going to improve on their potential, you know, to have legal services versus where they are currently, that fits that criteria without a lot of math, so to speak.
So, and my second question, and it was just 2 questions. My second question was, I was really intrigued by the service models and the evaluation of level of risk. And because of the slide that you showed that showed us what the data requirements would be for a model that has a moderate risk, what I took that to mean is that based on the level of risk assessed, so highest risk for software, you know, without lawyer involvement. What I think I was intuiting is it's not that the highest risk service models are prohibited, but that maybe there are more data requirements or more disclosure requirements or something like that. Is that how you address the risk?
That's right. And maybe more frequency instead of just quarterly. We'd like to see this data from you monthly. You know, the goal being to stay ahead of it and to determine if there is some issue. It's interesting, you know, algorithms, once the algorithm has performed its 20 instances of doing the issue correctly, nothing too much changes with that algorithm. By contrast, we've had a little more, I guess, discomfort, if you will, with non-lawyer providers, where there's this human, and you kind of need to be comfortable that the lawyer oversight is indeed consistent and sufficient in order to be sure that the non-lawyer provider is doing the job right. Now, that said, we're in the early days. We've only got data so far from 2 providers because they're just starting to ramp up. So as we go on, I think we'll learn more about whether the data requirements we put in place are sufficient.
Thank you.
Okay, then, sorry. Can I move on to the next question, or does somebody have something?
I had a couple of questions, Kevin.
Okay, Kevin, I'll put you on the list. Sorry, Marta already raised her hand, so I'm going to call on Marta next.
Thanks for the really great report. It was really helpful and very interesting. I'm curious about when you were putting this together, what Utah did in evaluating the underemployed lawyers in the state as part of its analysis in coming up with the Sandbox program. And I have another question too.
Yeah, well, you're raising a very critical element of this, I think, which is there is lawyers who invested a lot in, you know, law school and other things in order to be out there practicing law, who are fearful that this is going to undercut their ability to make a living. And one piece of information about that is that hasn't happened in the UK. in England and Wales. There hasn't been some shrinkage in the overall amount of legal services. Another answer to it is that, you know, the lawyers who are underserved or underemployed may do better partnered with somebody that can market more effectively or organize more effectively or operate a law firm more effectively so that they can do the part that they know what to do with, which is to practice law. So I don't know, Marta, if you're asking the political question, which is there's lots of lawyers that this, you know, that this is disconcerting to, or if you're asking about a sort of a data question. I don't think we really answered the question, you know, will more lawyers have less work as a result of this? I think the other theme we have and thinking we had there is this is about expanding the market and increasing the demand more so than taking the work away from people who are already getting hired by clients.
Yeah, I was more curious about whether or not that was part of the analysis that you did in putting together the program that you did, if or not. And then my other question is in the 2-year period in which the, I guess the certification or license period is going on, what is going on during that 2-year period to analyze or watch over these entities that are in the sandbox?
Well, our office's responsibility is to continue to regulate them. That primarily involves making sure the data is coming in that they're committed to supply to our office on a monthly or quarterly basis. But we've also got in mind doing some secret shopping. We've got our consumer complaint elements in there. And you know, if it's a lawyer who's involved in some mistake that's been made, we're trying not to become the disciplinary office for lawyers, right? I mean, if there's a problem with something that a lawyer's done, even though it's in the form of a entity in the sandbox, we'd like to make sure that stays with the disciplinary office.
So then what is your complaint process? Sorry, I don't mean to, I guess I'm asking now a third question, my apologies.
I mean, the short answer is the complaint process at this point is we will deal with the order requires us to make a complaint process available to consumers and respond to their complaints. That's all the order says. I think this is this idea of, you know, jumping in and to some extent needing to figure out which way we're going to swim once we're in the water, honestly.
Thank you.
Okay, I think Neil was the next person to have a question. Neil?
Thanks, John, for that presentation. I guess I've got a couple different questions, so I apologize. So you mentioned that there's a board and then there's an Office of Innovation. So am I right to presume that the board is volunteer and that the Office of Innovation is staffed?
Right.
Okay. And so how many people work for the Office of Innovation and where are you folks getting your funding from?
At this point, there is an executive director, a project assistants, and a data analyst. So there are 3 people, all who are on a contract basis. Our funding so far has been from SJI, the Strategic Justice Initiative. SJI, Strategic Justice Initiative. We are basically using grants and foundation money in order to support the office for this initial 2-year period. I think we assume down the road that the regulated entities need to support the regulation, just like lawyers support the regulation of lawyers.
Okay. And then my last question is, you mentioned that one application was denied, and I don't know how much you can discuss that, but was that denied by the court, denied by your board, and why was it denied?
One thing I'll tell you, we had a good schooling this morning on open meeting law. We've considered the applications while they're pending to be in a deliberative mode, okay, and not unless and until the court acts on it does it become a public, you know, determination. And in that case, we do post the court's order and the recommendation that we made about that person. But that said, my memory is that it might be that guy from Florida. You know, who just it didn't fit being suitable for the sandbox.
Okay. Thanks.
Okay, the next question we have is from Andrew.
Hi, John. Thanks for your presentation. I have two questions as well. The first is, did Utah consider antitrust issues when determining who should regulate the sandbox? And if so, did that inform your decision to house the regulator within the Utah Supreme Court for state immunity reasons?
We were, I guess, tuned into antitrust considerations, maybe not in a real overt and direct way, but it was always a working assumption that this should be under the direct auspices of the court. So we have encouraged our bar leadership to find ways to reimagine their organization around the idea that lawyers may not be the only providers of legal services in the future ahead, and that if you're going to be the society for those who provide legal services, you might want to think about making your organization relevant to people other than just lawyers. I mean, I don't know how California handles it, but right now the Utah Bar is where licensed legal practitioners are asked to group. It's also where paralegals are asked to group. But at this point, that's still, they've not embraced the idea that legal entities could be providing legal services and that they need to probably service them as well. So I'm sidestepping your question a little bit because it's just really only been the intent to have this under the auspices of the court. I mean, I've been astounded by the attention we've been able to receive from the Supreme Court directly. Maybe it's partly due to COVID, never a silver lining thing, but we're able to make these presentations of applicants once or twice a month to the court in their conference dates. So to have that capacity to directly deal with the Supreme Court, I think was critical to being able to get this off the ground.
Let me rephrase the question slightly differently. The members of your board, how many there are 13 members of the board?
There's 11 members of the board.
And how many of those are attorneys?
Becky, help me out with this. Becky's not an attorney. Tom Clark's not an attorney. We have 2 express citizen members. I think the majority of the board may still be lawyers, but there is definitely some non-lawyers participating and directly some public citizen representatives.
Okay, thank you. That's very helpful. I appreciate it.
Okay, 1 second. Okay, the next question is from Stephanie, who's a member of the public. Her question is, if an entity is authorized to participate in the sandbox and then wants to amend what it is authorized to do, is there a mechanism for them to pursue that change?
There is. Every time somebody's authorized, it's made clear in the communication to them. If you want to do something more, something different than this, let's say, for example, you want to move from 50% or more lawyer ownership of your entity to now a situation where it's going to be a minority owned by lawyers and a majority of the entity owned by non-lawyers, you're changing service categories, service models, and you would need to come back and submit a request to be able to be authorized to do that.
Okay, and then next we have Kevin.
Hi, John. Thank you for your presentation. I have a couple of, I think, straightforward questions, but first is, I noticed you're talking about the slide you had where you had the different levels of risk, and it had lawyer working for a non-lawyer. I'll tell you why I'm a little bit concerned. And my question is, when you evaluate the level of risk, do you consider the experience of the lawyer? And the reason I'm asking is because during the loan modification dilemma that California and most of the country found itself in the late aughts, I had several students who got all wound up in that problem by essentially working with lawyers from out of state and some non-lawyers inadvertently who had represented themselves as being lawyers. And they ended up with some debt of their own on top of their student debt. So I'm wondering, when you're assessing risk, do you take into account the experience of the lawyer who's being employed by the non-lawyer?
Well, the answer to that, I think that's a straightforward question. I think the straightforward answer is we don't. We have worked really hard to avoid presuming things about what the rules ought to be for participants in the innovation that create barriers at the front end that may not really need to be there. The two we have allowed for, or the court has allowed for, is no disbarred lawyers. We managed to decide we should not have disbarred lawyers. I think they can maybe own no more than 5% of an entity that's providing, that's in the sandbox. And then if you have a criminal record, you need to disclose it, a felony criminal record, and we would evaluate whether that felony criminal record, was somehow or another a disqualifier. On the question of, the experience level past that, this is a hard thing for lawyers, for all of us, I think, because we're so set in our way of thinking about these things. I think our answer to that, and I don't remember Eric's last name, but the professor in economics is, the question here is, will the market take care of that issue? If the people behind this entity don't have the sophistication and experience that other lawyers would have, then will they simply fail in the market? I guess is probably the working logic that we have about that type of a question of competency.
Okay. And the second question is just a very specific question. Another one of the slides where you listed the applicants and the numbers who have been approved, sent to the Supreme Court. You listed, I think it was 8 applications have been tabled. And in parentheses, it stated referral fees. Could you elaborate on that a bit?
I'm glad you brought that up, Kevin. That is, as we've learned, that's probably one of the bumps in the road. Peer referrals. Here's the horror story that is behind that. Isn't a horror, it's a potential horror story. And that's that a lawyer under the rule could set up in the anteroom of a chiropractor and have the chiropractor, who's a trusted provider of services to the patient, get paid a referral fee every time the chiropractor sends them to the lawyer in the anteroom. That the court decided, after seeing a handful of applications which were exclusively in just what we call bare referral fee arrangements. No, integration of non-lawyers, no effort to really meet, just helping pay referral fees to non-lawyers. The court decided that issue needs to be studied more carefully. And that's been referred back to the Rules Committee to try to address.
Okay, thank you.
Sure.
Next, we have Greg.
Hi, John. So thanks. Wonderful presentation. I just want to, and you may have covered this, so I apologize ahead of time, but in terms of, I understand that participants will be sharing data and making disclosures based on the model and the risk that's assigned to the particular model that they're pursuing. I'm just wondering, and I think you had said it on one slide that the first 20 or so customers, there would be a review. Is there any mechanism for, and I know you, in your answer to Marta's question, you referred to secret shoppers, but your office coming in and doing random audits to make sure that the data that you're receiving from participants reflects reality?
Yeah, I think that's on the table. We have, I think the order permits us to request more information from them, and this certainly would include the prospect of auditing them. What we're learning is that, by the way, most of these applicants so far, there's actually a Utah lawyer leading the effort. They've just got some idea, that's innovative, but they aren't necessarily the best at generating data. We probably have easier time getting the data formatted and sent back to us if it were true tech companies that were doing these things, but they're lawyers that are, kind of inventing things as they go. So I think if we see problems with the data flow coming back from someone, we'll be on top of that, and we'll have to be on top of that. I mean, as you might imagine, the Supreme Court cannot end up with egg on its face over this. I mean, this is a brave step forward, but we've got to really watch their backs for them, is how we look at that.
If I can ask a question, I'm not sure if there are others still in the line. But you mentioned that the rule changes went out for public comment. It sounds like almost a year ago, about a year ago. And I'm really interested what kinds of comments, if you could tell us a little bit about what the reaction was, because I was struck by how negative the reaction to the proposals that ADLS sent out to public comment were. You could read that as lawyers just being change averse for a whole variety of reasons, or you could read that as being averse to change that isn't carefully managed. And I'm wondering whether you had any more favorable response in.
Sure. Well, Becky can correct me if I'm not remembering this correctly, but I think the comments generally went about 2/3 negative, 1/3 positive. The 2/3 that were negative, I don't mean to discount them all, but were primarily lawyers concerned that this was going to allow the big four in, or, you know, some other element of a concern over changing things, or I think in fairness, concern over the quality of what was going to be provided in the way of legal services and the like. The other 1/3 really kind of came from, you know, people who understand the access to justice problem and see this as an important step forward. Now, a lot of those were great substantive remarks, and the court considered all of that and did adjust to some extent. The other thing we did, Justice Tucker, is we suggested to the bar that they form an independent committee to assess this for the bar and let the bar, you know, apart from this committee, weigh in as to what they thought and didn't think. And they formed a committee of 15 or 20 people who really worked, you know, alongside of us, but with the specific concerns of the bar as their focus. And ultimately, I think that helped us get the Bar Commission's comfort level with a few tweaks to our recommendations to support what we were recommending to the court.
Thank you.
Okay, next we have Thomas Green.
I just needed to unmute. So thank you for that presentation. That was very helpful. But the question comes in sort of an A and a B. Is there a quality standard that is explicit or implicit in your approval, which is one way of asking the question? The other one is, what is the standard you use to decide that somebody should be ousted from the sandbox? What are you expecting from these people quality-wise?
Sure. I think on the quality issue, you know, we had one applicant come along who he had some idea around Google metrics or something like that. He was going to use one of these. You remember that, Becky? He was going to use some kind of voice interface thing that was available through, I think it was through Google, to help develop criteria, basically an interface with people to give them advice, and it was going to learn. And what we found out as we worked through that with him is he didn't really understand how the system that he was proposing to use was going to operate. And so, you know, I guess we came to the conclusion that unless he could demonstrate that he could competently deliver the data that we were expecting him to be able to deliver, we weren't going to be able to advance that particular application. But Tom, I think your question is more about the quality and or competency of the legal advice itself.
Right,
As opposed
exactly.
to, yeah, and I think that's this question about the market, you know, and what the market considers sufficient or not sufficient. If we get involved in trying to decide if, well, I'll say one other piece about that though. We've had a great discussion with our court around lawyer oversight of non-lawyers, because it's in the context, you know, the assumption is the lawyers can give competent advice, just like when they got licensed to practice in the first place. But if it's a non-lawyer, the question is how much oversight is the lawyer giving them? On the one hand, if the lawyer is flight specking everything that non-lawyer does, well, you aren't creating much efficiency. On the other hand, if the lawyer gives the person, you know, 3 sentences of instruction and then cuts them loose and never verifies quality control or does anything to assure them, well, that's not okay. And I think the other piece there is that lawyer's license is at risk at that point, right? Because the competence requirement didn't go away for that lawyer who's in that mix. But past that, I don't know that we've formulated some test around them demonstrating that they're competent to provide the service. Again, I think if Yeah, if they give wrong advice, we should learn that through our feedback loop.
Okay, but everybody, I mean, everyone makes mistakes. I probably made 2 or 3 today. But what is your? I mean, this may not have come up since you have so few in the sandbox. But what's your sense of what would be sort of a paradigmatic? We need to get this person out of here. I mean, 2 mistakes, a really one serious one, or what? Is there? What is the current thinking on that?
I'm going to kick that to Becky because she's been working with our data scientists around that issue, and I think she's probably got a better answer for that. If that's all right.
Well, so if you go back to some of the research I presented, that lawyers make mistakes about 25% of the time that are bad enough to make the work incompetent is fairly consistent. 20 to 25% of cases lawyers mess up bad enough. So the first idea we had was, well, okay, you have to do better than that. But we didn't think that the court would tolerate that. So if you have a 10% significant problem at this point, that would make us start asking you a lot of questions. And we would try to figure out if this was a reporting problem or if there was really a quality or competence problem. And since none of this is, we've had no complaints and no evidence of any kind of problem yet, I think once that happens, we'll figure out what to do. And it would range from, we're just going to ask you some more questions and keep a closer eye on you and send more secret shoppers in, to you have to stop right now until we can figure out what's going on, to I could imagine you have to stop right now and you're out.
Got it. So I've got one other question. So I understand complaints. I used to work for the Department of Consumer Affairs here in California, but if somebody screws up a will, the person whose will it is not going to know it was screwed up for years. How do you, I mean, is that where your audit powers would come in, John? Or how do you make sure that a person who doesn't know anything about the law is going to be a useful or a really good source of whether the provider is doing a decent job?
Well, these are great questions, and we don't have good, ready, quick answers to them.
Yeah.
But I think one answer to that is, do we know that when a lawyer does the will, right? I mean,
point well taken.
That's part of it, is to be kind of assessing, this against that. We do have a participant in the sandbox called the State Guru, which is a, algorithmic sort of generation of estate and will planning documents, where I think that is the 20 instances generated by that algorithmic process is going to give us some indication if they've got a problem or not, if that's reviewed. I guess the one-off, I'm trying to think, I guess if you had non-lawyer providers of wills who are writing trusts and, estates and trusts and wills, and then maybe we wouldn't know about that for a while.
Okay. Are there any powers, John, that you would, thinking about it now, that you'd want to have? Is there anything you would, powers, or what tools, now that you're in this, I guess about a year, anything you see that you'd want to have now if you were rethinking it?
That's a really good question. I guess we're into it a year. We're into it really 6 months, but we're only now starting to kind of see the data and see what's working with people. We're doing a lot of bootstrapping, to be honest with you.
It's cutting edge. I mean, that's
We're learning from the first 5 applicants what we need to do different and do better, with the next 5 applicants. And we're watching what happens with the data flow on the first few participants to see if that's the right set of data flow. As far as powers, I don't know. I guess nothing comes to mind, to be honest with you.
Okay, thank you. Very helpful. Very, very helpful.
Okay, the next person.
I'm going to jump in now and say I think we need to move to the next presentation because time is short. While we give 1 minute for slide setup to the next presenter, to Mr. Moore, Professor Moore, I want to thank John Lund for that presentation. It was wonderful. And I want to ask everybody to, I don't know if we can do this by show of hands. Are people able to stay until 5 o'clock? Can I sort of see, Can I see a hand raised for anybody who can stay till 5 o'clock? Let's put it that way. I see some people don't have hands raised. We will be losing some people if we do that. But most folks are there. Because we do want to hear from Mr. Moore. We do want to then have a discussion of our work plan and of subcommittees that will flow from it.
If it'll be any help, my presentation is going to be very short.
Okay, well, that will be a help. Thank you. I don't want to cut anything off, but we'll let you start and see how far we can go. Hopefully we'll finish closer to 4:30 than to 5.
Kevin, are you going to control your own presentation?
I hope
I
so.
assume so. Okay. And you're going to share your screen, correct?
That's correct.
Okay. Perfect.
You can see it okay?
Yes, we can see it perfectly.
All right. What I'm going to be talking about were 3 recommendations that were made by the ADJOURN task force. I pronounce it ADJOURN. Everyone else seems to pronounce it ADJOURN, but so it goes. The ADJOURN, the rules subcommittee worked on a number of rules, but the rule that it worked on the most during the year and a quarter, year and a half that ADJOURN was in business was Rule 5.4. But I'm not going to talk about Rule 5.4. I'm going to talk about 3 rules that came in toward the end of the process, or 3 considerations that came in. All right. And the first one is proposed Rule 5.7. California has no Rule 5.7. Decision was made that we already permitted the type of activities, which is law-related services, a lawyer owning a law-related service and providing services to a client. And the requirements, we had good case law that already addressed it. We also had a little bit of a twist that dealt with when there was a fiduciary duty that might be owed to the person to whom the services, non-legal services were being delivered. And it just made it pretty complicated to draft a rule. And we decided we weren't going to do it. About 37 states have such a rule in one version or another of the model rule. The thought was that it's possible that if we were to draft a rule such as Rule 5.7, perhaps put it out for public comment, get it approved, lawyers in California would become aware of it. Other non-lawyers might become aware of it, and it might promote innovation that could increase access to justice in terms, not so much to deliver non-legal services to businesses and so forth that would typically be the users, but to the people law sector. And it wasn't something that we debated a long time. We raised an issue early on in the process. We put it on the back burner, and then it came back up again back in January, and our work was going to be done in March. So the idea here is really a consideration. Lawyers could be subject to discipline for providing non-legal services. Lawyers could also, in certain circumstances, could warn the clients that the services they are not providing are not legal services, and therefore the rules wouldn't apply. But the main point here is that this was just a suggestion to try to encourage innovation in the provision of services that are related in some sense to the practice of law. If this next slide talks about what these non-legal services were, Most jurisdictions refer to the services as law-related services. I think New York and a couple of other jurisdictions refer to it as non-legal services, but it's the same concept that it is going to be services that would typically be performed in conjunction with the practice of law, but that a lawyer could own a business with a non-lawyer in providing these services. There might be able to reduce the costs that are involved and be able to provide these types of services to more people. This second arrow point here describes some of the types of services that have been used or have been engaged in by lawyers under Rule 5.7. But that's Rule 5.7. Again, this was a rule we proposed to the Supreme Court that to the Board of Trustees, that it might want to circulate a rule for public comment. The Board of Trustees decided not to do it, but the view was that this might be a good rule to test in a sandbox, although a sandbox wouldn't necessarily be necessary. We do have a draft rule that we can look at a future meeting if people are interested. The next rule, or I should say set of rules really, that raised a concern, and this really came to the forefront in November of 2019, a few months before the end of Adel's term of service. There was a Court of Appeal case that came out in California, Jackson against LegalMatch.com, in which the court found that LegalMatch.com, which is a service that was matching lawyers and prospective clients without necessarily evaluating the lawyers or making a determination as to the quality of the lawyers and making any representations, trying to actively match lawyers and prospective clients. It was done pretty much automatically or algorithmically. The court found that this was a referral, and because it was a referral, if the legal match were not a qualified lawyer referral service, then any of the lawyers who were using it were essentially violating the rules of professional conduct. There are two rules of professional conduct, two parts of Rules 5.4 and Rule 7.2, which state that a lawyer can pay fees to a qualified lawyer referral service, but can't pay fees to a lawyer referral service that is not qualified lawyer referral service under the statutes and rules of California. That caused a great concern. And the suggestion was we didn't have time really to look closely at the lawyer referral rules, but we suggested this was a future avenue that the next implementation body, which is essentially this group, this working group, should take a look at lawyer referral services. Now, the end of this story, for what it's worth, is Legal Match did apply to become a qualified lawyer referral service. Their application was originally turned down, but last September it was approved, and they are now a qualified lawyer referral service. So that particular issue no longer exists, at least for LegalMatch.com, but it is still an issue that we might consider looking into during the term of our service. The last rule, or I should say set of rules, involved looking at perhaps revising the California rules of professional conduct that deal with advertising and solicitation. Now, those of you who were involved, for example, Greg, Toby, staff, and everyone with the Rules Revision Commission are well aware that California, after probably almost 40 years of having a single rule that dealt with advertising and solicitation, adopted a framework similar to the ABA model rules, which has 5 or 6 separate rules that address different aspects of lawyer advertising or solicitation. We were pretty pleased that we were able to get that through. And we are now trying to go for some sort of national uniformity. And the California Supreme Court in May of 2018 approved the rule with no changes, or the set of rules with no changes. And then in August 2018, I'll give a thank you, ABA. The ABA decided to streamline their rules and cut their rules down from 5 to 3. And so there was a suggestion that maybe we should revisit these rules and streamline the rules. Now, realistically, I'm not sure that the current rules in California that deal with advertising, yes, they can be streamlined. Yes, we can attempt to achieve national uniformity by more closely approximating the American Bar Association. But I think the 2 key rule changes that we might consider would be, first, to deal with solicitation. Right now, we have a prohibition on real-time electronic contact, which deals with things like chat rooms and so forth, which probably we shouldn't worry about that in terms of solicitation. It's the idea that no matter how inarticulate you, the lawyer, you are viewed in the eyes of the law as being highly skilled in the arts of persuasion. And therefore, any prospective client will be putty in your hands. And if you are able to get a prospective client in the same room with you or on the phone, they will be putty in your hands, and they will hire you whether or not you are competent enough to provide them with good, qualified, quality representation. Realistically, I think that the American Bar Association got it right with their revisions to that particular aspect, and that is that they focus on live person-to-person communication, live person-to-person contact, which would be in person or over the telephone, where there could be that give and take going back, and they put a prohibition on that, but then allow certain exceptions. Those exceptions are if the person being communicated with, where the lawyer initiates the communication, is a family member, or it's a client, or a previous former client, or if the other person is a lawyer, then the lawyer should be able to resist your importuning. The other new twist that the ABA put in is that there is solicitation allowed for people who use lawyers in their business. So you can contact business owners and offer your legal services if you're offering services of the same type that these people and their type of business would ordinarily use. So those are changes that could be made. The second change that would be of interest in making deals with social media advertising. And that is, they refer to, you must include an address with any advertisement or communication or solicitation that you make. And the ABA has changed that to just any kind of contact information. I don't think when we used the word address, we didn't use office address, we just use address. That could be interpreted as office address, a physical address, and that's really not what's necessary when you're dealing with social media. It's just to give the bar an opportunity to identify the people who actually might be the prospective clients who might have a complaint, or a client who has retained you who might have a complaint about the advertising. But realistically, who does complain about lawyer advertising? Is it the people who are out there, the prospective clients, or is it other lawyers who are in competition with those lawyers? So that's pretty much my presentation. Like I said, it's a short presentation. These are not rules that we delved into in any great depth on the ADL's task force, but they are just things for to take into consideration going forward. If there are any questions, I'll be happy to answer those.
Kevin, thank you very much. That was excellent. And of course, these rules are part of our charge. So it is very helpful to have you give us an introduction to that this afternoon. Any questions?
Doesn't look like there are any hands raised.
I promise it would be short.
Well, that helps us make up some of our deficits. So unless anyone comes up with any last minute questions, I'm going to turn the mic over in a moment here to Randy to walk us through the work plan that staff and some of us in the leadership have been looking at. It's obviously a little more concrete in the near term than it is in the out months of the almost 2 years that we will spend together. But I think it's very helpful to have Randy talk to us about that and about subcommittees, which is an important piece of that and actually connects to the one, I'll say, action item from today's meeting that we'll talk to you about at the end of the meeting. So, Randy, it's all yours. Thank you.
Thank you. I'll try to be as efficient as possible. Lauren and Mimi, if you could jump to slide, I think it is 4 of the staff slide deck. What I'm going to talk about today is in section B of the agenda. We do have a plan. That's the main takeaway for this section. What you've heard today is very intriguing. It sounds very ambitious, but we do think there is a way to get from point A to point B by the September 2022 deadline. And it all starts by looking at the charter, which is one of the first things you may have looked at when you were first invited to apply or received your appointment letter. And the working group charter, if you look at it, has as a main component the sandbox recommendation. And the sandbox recommendation itself, actually you can go to the next slide. Is very interesting because it does say that the working group is assigned to develop recommendations for building sandbox, including some specific matters. But it also says that an assessment of the pros and cons of the sandbox as a methodology, essentially, to foster experimentation, innovation, to promote access, is also part of that charter. And so while we are asked to do something that ADLs or ADLs really didn't have time to do and really couldn't facilitate in terms of board outright decision to say, yes, we want you to do a sandbox, we're committed to stand up a sandbox. And that is really to assess the merits of the sandbox as a methodology. I think John put it well when he said it's an experiment of an experiment, basically. And this experiment, I don't think the jury has returned a verdict yet on it. What the jury needs, though, is as much information as possible in order to decide whether this can work. And so the proposal, the lion's share of the charter, is focused on developing the details of a sandbox, implementation aspects, et cetera. But it will also conclude with this concept of, well, now that we've built it, we don't want to assume that they're going to come. We want the Board of Trustees to understand what are the pros and cons. So let's keep that in mind as we go through this process. If I were coming to this cold and sat through this meeting, and maybe this is stating the obvious, but I would say, wow, Becky really convinced me that there's an access need that needs to be addressed. Crispin gave me confidence that some of these things are already at work and have been at work without the sky falling. And John has just given us an incredible roadmap for how it's being done right here in the United States. You know, why is it going to take us 2 years to do something that seems so obvious? But I think that would belie the complexity of what we're endeavoring to do. Now, on top of the whole sandbox proposals, the last part of this current slide is that Professor Moore, Kevin just addressed the non-quote unquote sandbox proposals, the entirety of the lawyer advertising rules, lawyer referral service regulation, lawyer provision of non-legal services. And there was one other part that the ADL's task force recommended, and that is also included in a charter, and that is independent of the consideration in the sandbox of applicants being allowed to modify the fee sharing rule, professional independence rule 5.4, that the working group to also consider on a completely separate track possible rule amendment proposals. What the board has done, and really the result of ADL's good work, and also picked up and carried forward by COPRAC, is that we submitted at the end of last year the ADL's proposal for a modification to 5.4 that would allow fee sharing with a nonprofit organization that hired or retained a lawyer, even when the fee is not a court-awarded fee. The current rule allows for that exception for court-awarded fees, but let's say the matter ends in a settlement without a court award. The rule that's been proposed by ADL's got put out for public comment and refined by COPRAC, and now is been submitted to the court, would say that you could similarly share that fee when there isn't an actual court award action behind it. But that was viewed by ADL's as being somewhat of a modest, if any, reform to the fee sharing rule. So this group is also being asked, again, separate and apart from the sandbox, is there something more we could do with that rule? And I would say that perhaps Arizona is probably the most aggressive model for what you could do with that rule without having a sandbox. But there'll be more on that to come. Next screen, please. And so there are 7 sandbox related subparts in the charter. In fact, the first subpart, when staff reviewed it, we identified very discrete deliverables, one being a scope recommendation and another being sort of a regulatory and governance recommendation. And in fact, the chairs mentioned the fact that we're going to have subcommittees, and we would have 2 subcommittees hopefully formed soon after this meeting. And the 2 assignments to those 2 subcommittees, one would get the scope recommendation assignment, and the other would get the regulatory structure and governance recommendation. So we would be jumping right in and going to the first subpart of the sandbox recommendation and taking that up at our February meeting. But there are 4 non-sandbox deliverables, and when you add that to the 7 subparts, the 2 that are in the first subpart, there are at least 12 deliverables that we have to complete. 13 if we need to reserve a meeting to really delve into the final report and that aspect of it that deals with the pros and cons. And so we have come up, and you can go to the next screen, with a game plan that will have at least 13 plenary session meetings of the working group, in addition to as needed meetings of subcommittees. And it looks like we're going to have initially 2 subcommittees, but it's quite likely that we could have more. It's without prejudice to having more subcommittees. You could, for example, see a subcommittee for attorney conduct issues that will tackle much of what Kevin described in terms of those other parts of our charter. But this screen shows you, and CH stands for charter, not chapter, but that we have tried to structure the project plan and timeline around these specific deliverables: the scope recommendation document, the structure and governance document, the required changes to laws and rules, the criteria application process, the fact that there are certain technology issues. Some were raised specifically in the ADL's report. data and metrics evaluation, the important piece of compliance and enforcement. And I'm not going to read them all to you, but in order to do that, we have created a plan that has those 13 plenary meetings plus the options for subcommittee meetings in between. And the way we have divided up the creation of the agendas and the items to be acted on each agenda is to really contemplate that each of these discrete items would have at least 3 discussions. And so at the very next meeting, we would assign to our 2 subcommittees the 2 action items that we would discuss and hope to vote out, a scope document and a structure and governance document in February. But if it requires further discussion and there's input to the subcommittees and a redraft is needed, then we'd continue that at the April meeting, but we would add the next assignment matter onto the barbecue to keep the train rolling. And hopefully by the 3rd meeting on any of these discrete deliverables, we will actually take a vote to resolve it. Next screen, please. And so the 2 subcommittees that we've been talking about, much appreciation to the chair for coming up with some good names for them. But the first subcommittee is a scope subcommittee, and the scope subcommittee, first thing out of the gate for that subcommittee will be developing a scope recommendation. And we think that other things coming to the subcommittee soon thereafter would be the development of the eligibility criteria and application process, technology issues piece, and then the participant exit and termination. And the so-called SAGE subcommittee, which is more of an acronym, I think we've got that down as structure, assessment, governance, and evaluation metrics, or if you want to have that be the enforcement part. This is our SAGE subcommittee. And the first thing out of the gate for that group will be developing a structure and governance proposal. If you have looked at the Utah Supreme Court Order number 15 or the Innovation Manual, or even if you've just looked at the ADL's report, there is much work that's already been done on this front in terms of looking at issues such as scope. And we will be providing an assignment memo and background materials to both of the subcommittees. But we do believe that these are things that can come back in February. And if the subcommittee is not prepared to develop a recommendation document, even if we had a so-called issues outline, if you will, of the scope issues to elicit the feedback of the working group, that would advance the ball on both of these issues. And so just for example, when we're talking about, well, what do we all understand what the scope's recommendation assignment is? We've already talked about some of those things in terms of should the scope of a sandbox serve as an alternate means for, say, lawyers licensed outside of California or disbarred lawyers to apply and be able to render legal services. That's an issue. I don't think it's something that would get too much traction here. Doesn't seem politically viable, but other scope issues might be, as Kevin alluded to, what if there was a proposal that was not necessarily running up exactly against the unauthorized practice of law, but was a very aggressive model for a new form of lawyer referral service that really didn't seek to comply with the State Bar Act and the requirements for minimum standards of a lawyer service? Would we want that to be an appropriate sandbox applicant? Would that be within the scope? And so the scope recommendation document that will be assigned to the scope subcommittee as its first task will delve in all of those issues. On the structure and governance side, we did get some information from John about how this has been formed in Utah. It's under the auspices of the Utah Supreme Court. And that certainly is a model that we should study. But there may be different issues for us in California. And so looking at the structure and governance will be an assignment to the SAGE subcommittee, and something we would hope could be brought back in February, whether it is an actual recommendation document or just, again, perhaps more of an issues outline. We'd be looking to advance the working group's consideration of those discrete parts of the the working group charter with regard to the sandbox recommendation. Next screen, please. And so for the next meeting, first thing you want to look out for is that the meeting schedule, you heard the tentative dates for February and April, but we're going to try to flesh that out even more. And with those dates, you might see the very, very tentative project plan, so you can see what's coming down the pipeline. But the most important thing, and the thing that probably will come out hopefully directly after this meeting, is that the working group leadership would like to act to appoint these two initial subcommittees, the Scope subcommittee and the SAGE subcommittee. And you've heard so much information today, both from our great presentations and about the plan. We don't think we want you to volunteer right now for exactly what you want to participate on. So what we'll do is we'll prompt you with an email message from staff. And if you could, if you're interested in serving and you have a preference in terms of which of these two initial subcommittees you think your expertise might be used and valued, then we welcome you to quote unquote volunteer for a subcommittee, the Scope subcommittee or the SAGE subcommittee, and the working group leadership will take that under advisement, and as soon as we can, pump out the subcommittee assignments and the subcommittee rosters. And looking at a possible meeting in February, as soon as perhaps even the second week, we're going to try to get that out as soon as possible. So if you already know that you're interested on the Scope side or the SAGE side, if you don't even want to wait for that email to prompt you, you can go ahead and send the message to Lauren, and we will start assisting the subcommittee's appointment process.
Hey, Randy, so let me just interject for a second. Perhaps maybe what I can do is create a form site, like a online survey form where they just fill in their name and which subcommittee they'd like to be on, so we don't have to try to keep track of all those emails.
Oh, that'd be even better.
I'm going to say go ahead and send an email, because I'd like people to feel free to include information rather than just, I want to be on this subcommittee. Tell us a little why. And I
can add a field for that.
Okay.
I'll even create it right now while we're on this call, but yes, that's not a problem.
I also want to volunteer that anyone who wants to follow up directly with me is welcome to do that. I think my contact info is in the roster that's been sent around, but I look forward to getting to talk to all of you in a more intimate setting than a Zoom call for 40-something participants. And if you want to call and talk about subcommittees, that's certainly a welcome early step.
And let me mention that this would be the actual creation of a subcommittee as a group that would be subject to everything that Suzanne Grant described earlier in terms of notice obligations and agendas. And so if we get to the point where these subcommittees are meeting independent of the working group, then it would be mirroring the exact process that we have for the plenary group. We would be noticing the agenda 10 days in advance, having the meeting publicly accessible via Zoom, creating the agenda and all of that. And so we were able to do that with the ADLS group, and we're prepared to do that now if it's needed. And that was my attempt to keep us within our time constraints.
That was excellent. Very impressive. I think we need to include this on the list of things that we do on participation and discussion. So now that Randy has romped through the discussion plan, if people have questions about the work plan, if people have questions or comments about the work plan, please do share them.
Can I just ask that when the email goes out, there's there's the description again of the different roles of the subcommittees that accompanies that email?
Sure, I can add that to the form. So you just click on the link and then it'll explain what the different subcommittees are. You'll indicate what your selection is, and there'll be a box for you to explain why you think you'd be a beneficial addition to that subcommittee.
Thank you.
Reem?
Thank you. I just have a quick question. So once you elect one committee or subcommittee to be on, are you essentially no longer in purview of the other committee and their work? Or are you also still collaboratively involved in what's happening in the other group?
Let me respond to that by saying that there's obviously a lot of overlap in what these two subcommittees are going to be doing, and that everything that we do as a collective working group. So these subcommittees are going to get a lot of work done and a lot of decisions teed up, but they're not going to be making decisions by themselves. So if you work with one subcommittee but not the other subcommittee will definitely want the benefit of your knowledge, expertise, views, and so on in our collective meetings. And although Lauren is sending out a form where you can choose which committee you'd most like to serve with, I hope the form will have either one as an option, because we will have to do a little bit of juggling. Gosh, we're sure you could make contributions here, but we really need your expertise there, based in part on how people respond.
Sure.
Don't feel, however the subcommittees work out, that you are in any way being cut out of decision-making on anything, because you're not.
Justice Chuker, did we mention, I apologize if I missed this, that we expect that as the work of this group continues, that there will be other subcommittees as well, that we will be asking for participation on. This is sort of these would be the first ones that we would be needing to begin work on.
That's right. And Randy made the comment specifically in the context of rules revisions. So some of you with expertise in legal ethics rules may think, oh, I'll hold off and work on that committee when that rolls around, or join one of these committees if one of these committees takes on those responsibilities. That's totally fine. But we also do need to have expertise in rule writing on each of these committees, on legal ethics on each of these committees. So you don't have to join a subcommittee, but please do volunteer if you're willing.
I think another question people may have is, can you be on more than one subcommittee?
I won't say no at this point, but and you can certainly tell us if you'd like to serve on both. But I think that the subcommittee responsibility will be a fair amount of work, so it isn't likely to happen much, maybe not at all.
I was meaning, like, if there are, let's say, a rule committee came up later, separate of these two, and you wanted to be on both, but then
there's no reason, if you're ready to work on a subcommittee now, please let us know that now, and we can always make adjustments later, including putting you on a second subcommittee and having you work on two if we start a third subcommittee up. We just felt we needed to have a certain amount of flexibility going forward. And so that's why we don't have the plan absolutely nailed down as to exactly whether there will be a third, and if so, when it will start, or any of that sort of thing.
Do you foresee an ideal size for these subcommittees?
Well, we do have to honor the guidelines that we heard earlier this morning. So they will definitely be less than a majority of the entire working group.
Right.
But we will see how many people sign up.
Thank you.
And actually, to Reem's point about process, really the only advantage in terms of, and we don't necessarily adhere strictly to Robert's Rules of Order, is that when we have the ability to assign things to a subcommittee and have the subcommittee present it, in order to put it on the table for discussion, things that come to the main body from a subcommittee, we don't have to go through that formality of a motion made and seconded just to talk about something. If a subcommittee has already done some legwork and looked into it, we can put it on the agenda and call it for discussion without that formality. But other than that, if we're going to act on it and vote anything out, it definitely has to be voted on by the entire working group. And because all of these meetings in the foreseeable future will be Zoom, it's going to be a roll call vote. So everybody's name will be called and everybody will get a chance to decide every issue regardless of where you sit in terms of a subcommittee, or if you're not ready for a subcommittee quite yet.
And that's part of why we have a work plan that envisions, let's say, these first two scope and structure and governance documents. We have them coming, I think it's safe to say, at least to 2 meetings and possibly to a third before they're finalized, precisely so that we can get input from the entire group in each document.
I just have a quick question, follow-on question. In terms of, for those that have experience and led committees and subcommittees like this in the past, if you could provide time estimates as what is the time commitment for each one of those, scope as well as SAGE, just so we understand ahead of time what the time commitments are going to be.
We expect them to be comparable to each other, and we'll see if we can give you a little further information on that as well. Other comments, questions, thoughts? Well, because both of the last 2 segments of our program went more quickly than our informal time budget, we made up for the fact that some of the earlier ones went more slowly. I hope that didn't make anybody feel rushed at any point. Backing off from the immediate discussion of work plans, are there any comments or questions that anybody wishes to offer on the agenda items that we ran through today before we adjourn?
Justice Tukar, I'd been communicating with Crispin Passmore after his presentation. He wanted me to extend his apologies and thanks for understanding that he needed to get off the meeting after his presentation earlier today. I personally hadn't even realized it till he said, well, it's evening here and I've concluded my workday. So I know we were all appreciative of having him here, and he just wanted me to extend his thanks to you and to the working group.
Thank you for passing that along. And I would like to add my thanks to everybody who presented today. I thought we had 4 absolutely first-rate substantive presentations and lots of very helpful information from many of you at the State Bar on the procedures for what we're doing. So thank you all for participating.
Justice Tucker, real quick. I'm sorry. I didn't mean to interrupt, but I did wrap up the work plan discussion in terms of the chart and the subcommittees. I did want to just mention the last sort of 3 bullet points. I wanted everybody to be comfortable with the work plan and to think about their subcommittees before I powered through these last few points. And the last few points are, if you wanted to put slide 4 back up on the screen just quickly, is that the board action creating the working group authorized the chair to appoint advisory bodies such as focus groups. And we will be, as our product is being developed, looking to utilize that authority to maybe form a consumer focus group or a technology advisory body, because we want to be consumer focused. And while we couldn't put many quote unquote true consumers of legal services as sitting members of the working group, we do want to actually value true consumer input through the process of a focus group. Same goes with the technology side. The ADLS task force identified what was termed, and it was a new phrase I learned through ADLS, so-called dark patterns in technology. And so we have some technologists on the working group, but as we again develop our product, we might want some sort of advisory input from a very key technology folks. The last parts are just regard to public comment and public hearings. When it comes to regulatory provisions like rules of professional conduct, there will be public comment, formal public comment proposals. And if we also need it, ADL's conducted a public hearing. And if we want to conduct a public hearing, which would be essentially a meeting where we just hear input as opposed to deliberate and act, we can put that into the schedule at an appropriate time. And the last part I'll mention is outreach and surveys. ADL's engaged in some informal outreach. And while we don't have any specific plans right now for what that might be, we might be looking at having some educational opportunities or other outreach activities, again, as our project is further along. And this concept of surveys goes to the issue of empirical data on, say, California, public opinion on certain topics. And while we have experts sitting on our working group who have already done a lot of surveys and gathered a lot of data, and in fact, the ADL's group did a survey, and we have a Justice Gap survey. If we do need something in regards to that type of information gathering, it is again a tool in our toolbox to use to get this job done. And that's the rest of the work plan.
Thank you, Randy. And thank you for all the work you did in preparing for today's meeting so we could discuss these things.
There's one comment from the audience, just a closing thank you, but also comment that I'll read quickly. It just says thanks to, and this is from Stephanie Bond, who posed some other questions earlier. It says, thanks to everyone for this very informative and interesting session. I hope to be back to future meetings. I'm a Canadian with a client who is very interested in sandboxes. I too am interested as a former judicial assistant.
Super, thank you. And Lauren, can I promise everyone that to the extent the slides are not already posted to the OneDrive, they will be within the next day or so that anyone who wants to refresh on what they heard today will be able to have that written record to have access to that.
Definitely. We can probably get them up by the end of today.
Excellent. Well, it's been a long day, although not quite as long as I feared an hour or two ago. Well, thanks, everybody. Unless there are further comments, I think it's, Randy, I'm not cutting you off on something we still needed to do, am I? Okay, then I think it's safe to say we are adjourned until our February meeting. Thank you, everybody. It's wonderful to be working with such a talented group.
Thank you, everyone.
Thank you.
Thanks so much. Take care.
Thank you.
Bye.